Tony Ada, Senator Respicio, Senator Blas in the halls. We do have a quorum, so this legislature is called to order. The bill that we have with the committee report is substitute bill number 188-30, and I recognize the author, Senator Espadon.
Thank you, Madam Speaker. Good morning. Madam Speaker, I move bill number 188-30 COR down to the third reading file, and I'd like to speak to it.
And the bill is the substituted
As
bill?
substituted by the Committee on Appropriations.
Okay, so you may continue then to speak.
Thank you, Madam Speaker. Madam Speaker, this is actually a very simple bill, and it's in recognition of, I think, what we've seen over the past few years, especially during the times when the fuel prices, we saw gas prices go up, and one of the reactions by the general public to help offset the cost of the high cost of gas was basically to look at alternate means of transportation from their cars to perhaps motorcycles or scooters and even bicycles. And this bill basically addresses that change. And I believe that, of course, going forward, we're going to see a lot more construction on our roads. And again, I believe, and possibly even the increase in prices. Who knows what's going to happen in the world oil prices, but prices going up at the gas pump. And so we will probably see a corresponding increase in the number of scooters and motorcycles and bicycles on the roads as well. If it's any indication, we're seeing a lot of commercial businesses who are in the motorized vehicle business actually are expanding their lines of scooters and motorcycles and whatnot. And this bill basically allows for or requires for parking spaces for these two-wheeled vehicles. There are many times where we have pulled into a shopping center or whatnot thinking that there's an empty parking stall, just to pull in to find that there's really a scooter parked in that space, when in reality perhaps four scooters could fit in that one parking space. So this bill basically amends Title 21, which deals with the parking of off-street, what deals with off-street automobile parking spaces that are required by law. And the amendment basically is to add a new section K to it that would basically read that off-street automobile parking space shall be provided as follows. And under K, it would read, to the extent practicable, each of the sub-items A through J shall provide at least one marked parking space for use by bicycles equipped with a motor and motorcycles. And we termed it as such because bicycles basically means a two-wheeled vehicle. So, and then we said with motor. So now we're acknowledging scooters and mopeds and vehicles such as that. The other amendment that this would make to this section of the law would be to provide one bicycle parking space for each 20 off-street automobile parking spaces. And in essence, basically what we're looking at is bicycle racks. And again, I believe that, I think it was last legislature maybe, or maybe even this legislature, where one of the good senators, one of our good senators from Barragata introduced legislation that would require for more bicycle lanes and whatnot. So we would anticipate going forward, especially with the increase in population, that we're hoping to see more bicycle usage to not only provide for a healthier transportation mode, but also to benefit the ecology as well, in terms of not having to use fossil fuels to get from one place to another. So this bill, in essence, just in a few words, would provide parking spaces for scooters, mopeds, motorcycles, and bicycles, separate and apart from the regular automobile parking spaces. And with that, Madam Speaker, if there are any speakers who will speak on that, I know there are a few concerns that have been expressed by our colleagues here, and we'll address those concerns as they arise. Thank you, Madam Speaker.
Thank you very much, Senator Espadon. On the motion, Senator Guthridge, you're recognized.
Thank you very much, Madam Speaker. I want to commend the author of this bill. I think it's a great bill. It's very much needed. And I would hope that it would create a consciousness about the fact that we're still waiting for the Department of Public Works to fulfill its mandates by law to provide bicycle paths. And, I'm kind of worried, Madam Speaker, that we're seeing all the new road construction occurring. And there is a law, and I believe Senator Pangilinan was the author of that law, that requires that new construction of roads must provide for bicycle paths, bicycle lanes. And I don't see that on these new construction projects. I know it's not a direct aspect to your bill, Senator, but we need to somehow look at this bill as an opportunity to make the statement, what is Public Works doing? And why is it not accommodating these alternative methodologies of moving people from place to place? Also on the bill itself, I did talk to the author, and I think maybe we can do this through some technical activities by the legal counsel to ensure that the bill does incorporate the right language for motorized bicycles and non-motorized bicycles. Motorized bicycles would, I guess, cover scooters and stuff, but we want to ensure that the bill clearly defines non-motorized bicycles as traditional bicycles that are not aided by any electricity or gas or anything like that, because that's what we're also trying to promote as an alternate form of transportation. And I did point out to the author a couple areas where we need to do that, just to make it very clear to those that will have to comply with this bill should it become law, that they have to provide certain amenities to meet the requirements of non-motorized bicycles as well as motorized bicycles. Thank you very much.
Thank you very much, Senator Guthertz. On the motion, are there any other speakers? Senator Pangilinan, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I want to rise in support of the legislation and the proposed this proposed legislation. I think it recognizes and moves forward, looks forward to greater accommodation for things that are more healthy for our community with regards to individuals who decide to take advantage of the pleasant conditions of living on Guam. And one of the most pleasant conditions we have, of course, is our abundant sunshine and favorable weather. And we have made some changes, as the good author mentioned, about requiring bicycle lanes for construction and reconstruction of new roads. I was almost elated in the announcement of the reconstruction of Route 4, because when we started that construction of that road, I reminded the Director of the Department of Public Works that there exists statute that says that when you reconstruct the road, you have to provide for the bicycle lanes. And of course, the director at that time wrote back and said, "Don't worry, Senator, we're very much aware of it. It's in our design, it's part of our construction, it's part of our bid, and we're moving forward. We're going to put a bicycle lane there, and we look forward to that also." And so I place my trust in the commitment that they made and the assurances that they gave that, in fact, they had the engineers design the roads. And I kept looking and I said, okay, I think it's wide enough. I can see where the bicycle lane can go in there. And we continued, I continued to monitor and look at the construction and reminded and spoke with them a couple times, and they said, it's on track, we're going, and we're moving forward. And then all of a sudden, as more areas were finalized in terms of the construction themselves, I look at, wait a minute, something's wrong here. And of course, it turns out that they changed processed a change order, redid the construction, redid the plans, and took out the bicycle lanes. Now, I understand that they did this in response to some of the mayor's concern about putting a middle lane in the construction. Now, once again, Madam Speaker, I looked at it and I asked them, I said, you can do this. Even with the middle lane there, you can still provide 3 feet of space, and wherever you have the opportunity and the land, put in that. Maybe it may not be continuous, but of the 4 miles there, we can have 2.5, 3 miles of bicycle lanes where it can fit. And if not, then you just kind of veer off and get on the traffic, follow the pattern of traffic, then pick up the bicycle lane where it picks up on. But I don't know. They just don't think like this. We take the easy way out when we kind of do these kind of things, and it really is frustrating. And once again, I'm going to send a letter, even when we're doing these intersections right now. I'm going to remind these guys that we're reconstructing this intersection, and to put in a bicycle lane, even if it's only 300 feet of intersection, put it in, because that's what the law requires. And when you do the other roads, you follow the law once again and you put in the remaining. But wherever you reconstruct or construct new roads, even if it's not continuous, put it in. Because as we move forward, we can then connect those segments of bicycle lanes at a later time. So I'm putting on notice again the Department of Public Works. And the beauty of this, Madam Speaker, is that most of, if not all of the reconstruction and major constructions on these major roads are being funded by federal funds. So it really is not money out of our pocket, but we can use these federal funds instead of putting up $7 million in guardrails, taking guardrails that are in perfectly good shape. I don't understand that. Nobody drives on the guardrails. They drive on the road, yet we spent $7 million in guardrail reconstruction when we have potholes in the middle of the road. The priority and the thinking is warped. You know, it doesn't make sense. And this is not something that only I notice. This is people stop me and call me every day as I walk some of the streets and go to the post office. They said, Senator Ben. Most of them just call me Ben, and I'm very happy because, you know, as I said, you know, it was an inauguration, not a baptism, so my name is not Senator Ben, it's still Ben. So they call me, and most of them call me Ben. Some call me other names, but I still respond to those too. But they said, Ben, why are we fixing, look at the airport road, look at that nice, it is nice. The new guardrail's nice, but boy, the other one was nice also. It wasn't even crooked. Yet we spent, what, $400,000? $100,000 to take up and pull up those perfectly good guardrails and put in new ones. Why? Why couldn't we go down to the road between where Home Depot ends down to Route 10 and fix that road instead of fixing the guardrail? They're asking me this, and I'm saying, I don't know. I suggested that to them. I told them that. You know, people get frustrated when our government acts like this, and the priorities just doesn't make sense. $7 million in these improvements, and we understand the safety aspects of it, and when there is a safety aspect, I can understand that, and people understand and appreciate it. But boy, when something is perfectly good and we throw good money at it, not to even make it better, because it really isn't any better. The new guardrail at that airport section is no better than the old one. No better at all. In fact, I think these are worse because the old ones had cement pilings that are probably more sturdy, and these ones just have now steel pilings. But on this, back to this issue of what got me off track on this, is this bicycles. We will commit ourselves to ensuring that when we do this, we follow the law. And when people take advantage of now the enhanced infrastructure, transportation alternative that we are and we will build, then we can have these individuals have a good place to ensure then that their vehicles are safe, their bicycles safe when they lock it up, and we maximize them because of the requirement. And I think that we will encourage good health, good healthy practices such as riding a bike that saves you money and improves your health. And now you will have access to ensuring that you can feel secure. Like, because you can lock your car, but you can't lock your bike without the proper facility. And this will provide the proper facility for individuals in our community who decide to take advantage of free form of transportation and a healthy form of transportation. And they can be rest assured that they'll have a safe and a proper place to store their vehicle, just like we mandate other businesses actually, that we mandate businesses to provide a safe and secure place for those who decide to drive cars instead when they visit an establishment and feel secure in parking and storing their vehicles. So I thank the good author. I think, it'll be a question, that old proverbial thing, I believe, that if you build it, they will come. And we will provide this facility. Our people will use them. We will make these incremental changes in how friendly we can be to these healthier lifestyles, and in this case, to individuals who wish to partake of that lifestyle by using bicycles for their mode of transportation for either recreational or just plain old transportation purposes. Thank you very much, Madam Speaker.
Thank you, Senator Pangilinan. On the motion, Senator Uggan.
Buenas and Day, Madam Speaker. Madam Speaker, I would be remiss to not stand up and extend my support for this legislation and commend the sponsor for initiating it. Having had the strong appreciation for bike lanes, I attended the University of Denver for 6 years, and no, Madam Speaker, I didn't go 5.5 years. I didn't go to an extended 5.5 year education program. I was able to continue with my master's degree at Denver, Colorado. And one sense of appreciation is during the spring and summer, I always looked forward to my biking experiences over the weekend. Every Saturday morning, I'd wake up, go biking for about 3 hours, come back, just relax, and then start opening the books. And it gave me a very strong sense of enjoying the scenery, the greenery around those particular bike lanes, and just being able to incorporate some form of exercise during those years. And I anticipate that as a result of similar legislation such as this, and as a result of some of the ideas that the previous speaker had mentioned and shared with us this morning, that we're going to be moving in that direction in terms of making sure that any major highways that are constructed, that it incorporates bicycle lanes so that it can encourage many of our people to move into that particular direction and be given that additional assurance that there's going to be safety, some form of safety in the roads, because you no longer have to traverse on the regular lane, but you may have a secluded lane specifically for bicyclers and as well as runners. So I stand in support of this, Madam Speaker, because it certainly says one thing, and that is it recognizes that in fact we have individuals out in the community who enjoy biking, and we have families who also enjoy it. And as a matter of fact, I believe about 3 weeks ago when I ventured to one of our public beaches, there was an entire family of 5. 2 of them were the younger generation, young kids, between 8 to 12, who were actually bicycling with their parents. And I know that this incorporates bicycles with motors and motorcycles, but I look at the other aspect in terms of the health and also the family bonding component, and I think it certainly bodes very well in terms of ultimately looking at these items and putting them in place. So I stand in full support of this legislation, Madam Speaker. There's only one issue that I would like to share with our colleagues here, and I know that it was inserted here with a purpose, and that's subsection N on page 3. I noticed that on item number 3, it incorporates and requires lighting. I think that that may present an additional financial burden on some of our smaller businesses, but then again, I was looking at it also from the other perspective where perhaps it may encourage business owners to be able to ensure that the accommodations for parking for bicycles and motorcycles are perhaps placed consistent with subsection 6, which would be in direct view of the entrance of that facility. But I just wanted to share that with you because obviously when we're looking at small businesses, we're not, at least I don't view it as, we're not in the business of having them incur additional costs as a result of mandates, but we're certainly in the business of trying to encourage safety and other activities such as what this would provide. Also, Madam Speaker, just for purposes of consistency on page 2, line 25, if I can suggest, just to be consistent with other laws of the land, that territorial be deleted and that Guam be inserted to replace that, because it's really the Guam Land Use Commission. It's the GLUC, is no longer the Territorial Land Use Commission, and that was as a result of legislation that was passed, I believe, 5 or 6 years ago. So, Madam Speaker, if I can move for that slight amendment, I don't know if that would be considered technical because obviously we're dealing with this in its present form. But other than that, I stand in full support of this particular legislation, and I commend the good senator for moving forward with this, and I also commend the committee because it's also expanded a bit more to address other perspectives of providing these types of accommodations. Thank you very much, Madam Speaker.
So on the motion then to change territorial to Guam, on page 2, line 25, then without any objections, so ordered. On the motion, are there any other speakers? There being none, I would call on the author then to close.
Thank you, Madam Speaker. Madam Speaker, in light of the previous speaker's concern on the lighting issue, I would have to tend to agree. We don't want to impose really any severity upon small businesses who would really want to do this, but then if it would have an additional cost in terms of having to provide lighting, maybe, and I will just go ahead and propose it, because I think that lighting will be appropriate, especially for small businesses, because if they are going to be able to put the bicycle racks closest to their entrance and their windows or whatnot within view, that lighting may not be a problem. So just to make sure that we don't impose a hardship on the smaller businesses, I would move at this point to strike on page 3, line number 5, the word lighting, subsection 3 under lighting.
You want to delete rather than saying where appropriate?
I'm sorry?
Or something where appropriate or optional?
Well, again, it was pointed out by the previous speaker that under sub-item 6, where possible, bicycles parking shall be located within view of the building, entrances and windows. I think that will perhaps already give them enough lighting or at least access to visibility. And we also will have to recognize that a lot of times the bicycle riders are not riding at night. And so if they're going to be parking, and if they're going from their home to a destination, it's in all probability not going to be at night. So again, to alleviate that requirement, I think would alleviate the financial hardship it might impose upon small business. So on the motion
then to delete on page 3, line 5, number 3,
Number 3, lighting.
Without any objections or...
Thank you, Madam Speaker. And Madam Speaker,
to renumber.
yes, and we just renumbered. Thank you, Madam Speaker. Just to wrap, Madam Speaker, I appreciate all the comments and support. I believe this is essential going forward, and I too, in fact, when I went back to school at the tender age of 42, and to get my advanced degree, I did not have a car. I couldn't afford one, to tell you the truth. So I went everywhere with a bicycle, and and I remember there were a couple businesses that I'd go down to where there were no parking facilities for bicycles. So at one point I had left my bike leaning up against the building and whatnot, and it got stolen. And so I think it's essential that if we're going to go down this road, we got to make sure that and I was heartbroken, Madam Speaker, because I bought it at a real good price, $15 at a rummage sale. and it forced me to have to go out and buy a brand new one. But again, it is, you know, it is almost a violation of that personal property when people see an unlocked bike. You know that's your mode of transportation that you totally enjoy, and then somebody steals it because there were no facilities to attach it to lock it with. And so this bill provides for a rack that would, you know, that you can lock a chain onto and your bicycle. And I think that would definitely offer a sense of security to anybody going forward who has a bicycle. We're seeing it right now that there are a lot more bicycle riders on this, taking advantage on the weekends to utilize these vehicles, and also we're seeing a rise in the number of scooters and motorcycles out there. So to provide them their appropriate parking spaces, I think is only right. But for all the support that's been given so far, and I ask all the rest of my colleagues to support this bill, I thank you for the opportunity. Thank you, Madam Speaker.
So on the motion then to send Bill 188 to third reading file without any objections, and so ordered. We're now on Bill 383, and I recognize the author, Senator Respicio.
Thank you very much, Madam Speaker. Madam Speaker, I move that bill number 383 be placed in the voting file with some discussion.
Third reading to discuss.
Yeah,
So
third reading file, yeah.
yes, so please
Thank you very
continue.
much, Madam Speaker, and dear colleagues. As you know, under this legislative leadership headed by yourself, your edict was to try to make the legislature relevant again. And I think that's what our collective focus has been. I think every single member, both from the majority and minority, certainly committed to trying to restore the legislature to how it was, how we know it traditionally. I had a good conversation with our newest member, Senator Tony Atta, the other morning, where he was kind of recalling the days where his dad was a member of the legislature, and the kind of respect and prominence brought to that body at that time. I also shared with him my own experiences, 15, 16 years old, working in the legislature, and how we had the likes of former Senator Bel Arreola, Pilar Lujan, and other long-term, old-time folks, where you kind of had that kind of feeling where you know that a lot of debates and discussions were extremely passionate, but you know also that those debates and discussions were only limited to the session hall, and after session everybody got together. And I think, too, Madam Speaker, that's what we're seeing these days. We're seeing all 15 of us trying to conduct ourselves so as to bring honor and respect to this body. And the ways that we do that is we go above and beyond to show that anyone who makes contact with any member of the legislature also has to be beyond reproach. And I was looking through some of the old statutes, and the only statute I can find with respect to how people lobby the legislature is a very simple rule that merely requires an individual to register with the legislative secretary, and that's it. And so, you know, we're approached many times. We're approached by people who are working for businesses who try to get legislation through. I know that we shy and work very hard to shy away from special interest legislation, so you'll never see a legislation that would benefit one particular person. But really, you see a legislation that's broad enough, but we know it would impact certain businesses, or it would impact certain constituencies. So as much as we try to be as broad and general as possible, we still have to deal with that appearance of how this was brought to our attention. We also have to deal, Madam Speaker, with the fact that when we are in session, the public has access to us at any time, and we're called out to the public hearing room, or during a recess. Sometimes we invite them to come in the committee of the whole. And a lot of the decisions we make are based on the information that's given to us. So if we don't move forward on Bill 383 to require certain kinds of disclosures, we could very well find ourselves, and our successors may find ourselves, having to take advice from individuals whose decisions or positions may be motivated for other than purely good reasons. And so this bill 383 would first require that anyone who is a registered lobbyist to sign to do certain things. And on page 1, it defines lobbying as means any activity by lobbyists which is reasonably designed to influence the passage or defeat of any legislation, including meeting with legislators or employees of legislators, providing information and draft legislation to legislatures or employees of legislatures. So even our staff will be held to the same standards. Publishing any articles or editorials in favor of the passage or defeat of any legislation, organizing groups, paying for amenities or expenses in any amount above $1,000 per year in total, procuring goods and services from vendors in exchange for the passage or defeat of any legislation. And it also goes on to define what a lobbyist is. And a lobbyist in this respect is a member of the public appearing before a committee or the legislature in support or opposition to legislation, a member of the public who contacts their elected officials, government officials acting in their official capacity. So these definitions that I'm reading would not apply to a lobbyist. So to allay some of the concerns that if Tan Maria or Tun Wan had a rezoning request to the legislature, then certainly that's citizen type lobbying and they would not have to register with the legislative secretary. Government officials will not have to register with the legislative secretary because they're acting in their official capacity. Reporters, members of the media, employees or owners of publications engaged in regular reporting on news items, editorials, and other commentaries concerning legislation. These types of individuals will not have to register as a lobbyist. Or paid advertisements which contain a disclosure of the entity paying for the advertisement, an entity interested in the issuing lobby. Here's where I'd like to call also volunteers and campaign contributions within the limits allowed by law made to a senator or a senator's campaign committee. So also, Madam Speaker, what I'd like to call your attention to in the registration process, we spell out that they'd have to register their name, their business address, their name and address of person by whom they're employed, interest in which the person appears, duration of employment, amount of pay or in-kind compensation, the names of any papers, periodicals, magazines, or other publications wherein lobbyists cause to be published articles or editorials in favor or opposition to pending legislation. They would have to provide all this to the legislative secretary. What this bill also does, unlike what's currently in the present code, it requires that commissions are prohibited. So no person engaged as a lobbyist shall receive pay or in-kind compensation as a commission for lobbying based upon a favorable outcome of a lobbying effort. So obviously this means that if someone were a paid lobbyist, he shall not be compensated above or given a commission beyond what his compensation is. False statements are prohibited. No person engaged as a lobbyist shall circulate false statements concerning the issue or legislation being lobbied for or against either to officials, employees of officials, or to the public. Public funds prohibited. No public funds of any government entity can be expended to engage in lobbying. Former legislatures as lobbyists. It says here, no person who is a former legislature shall engage as a lobbyist for 2 years after the end of the last term held by the former legislature as a former legislator as a legislator. And we all know that former legislatures have privilege of the floor. But we've also seen that this privilege of the floor has been attempted to be widely abused. When we're in here deliberating on bills, resolutions, or when we may even be in the committee of the whole, the last thing we ever want to have to deal with or think about is a individual who gains access to privilege of the floor and talks to us about issues. Sometimes these issues are not even the issues that are before the body, and so that in and of itself has been distracting. So we've instructed our sergeant at arms and our central staff here, Madam Speaker, to ensure that this place that we're in requires us to be really focused, and anything that's non-session related should be put before us. And this bill also provides penalty that any person who violates the provision of this section by failing to register or update their registration and accepts a commission for lobbying, issues false statements in lobbying, uses public funds for lobbying, or as a former legislator lobbies within the prohibited time period for former legislators shall, upon conviction, be guilty of a misdemeanor and be prohibited from engaging as a lobbyist for a period of 3 years from the date of this conviction. So I hope that we're ready to do something like this, Madam Speaker. I'm hoping that we're ready to reform the manner in which this legislature and future legislatures are being lobbied. And I'm hoping that this bill would create an environment where we can, in a deliberative fashion, we can focus on the issues at hand, and that when we do interact with these registered lobbyists, that we can have some sense of comfort knowing that the individual is giving us information that's factual, and that they're not doing anything to mislead us in an attempt to get us to pass a bill, and the information they provide is absolutely accurate and above board. So I thank you for allowing me to present this bill. Did have a public hearing, and I offer this up for the body's consideration at this time, but I'm hoping, Madam Speaker, that we could support this. Thank you.
On the motion, recognize Senator Gutherts.
Thank you, Madam Speaker. I believe this bill is a very timely bill. I want to commend the author of the bill. You know, Guam is emerging each day into this millennium with many challenges before it. And I know my experience here over the last almost 3 years, or a little over 3 years, has showed me that you have different kind of folks that come to the legislature very regularly for different purposes. You have the regular villagers that come to ask for help to fix their village facilities or their basketball court. You have parents come who are concerned about issues perhaps at the schools. You have community organizations that come that ask for support for their causes. You have businesses that come that ask us to review legislation or to consider new legislation that might help the economy. And you have also others that come that have little more personal needs that, if converted into legislation, would be very much targeted to their interests rather than the public interest. And unfortunately, in those cases, it creates perhaps some dilemmas for some senators. I think most of us here have no dilemmas at all, except to politely say, I'm sorry, we cannot help you on this personal matter, which would require changing laws just to be very specific for your particular business, your particular interest. On the other hand, we don't have any thing in place right now that sets up the parameters of how we handle individuals or representatives of individuals or organizations or private enterprises that come here to lobby for special types of legislation. Now, in the Congress of the United States, they have very, very specific lobbying rules that emanate from a law, a federal law, a lobbying act that was passed by the Congress, both the Senate and the House, about 20 years ago because of the serious problems that they encountered with some of the behaviors of lobbyists that eventually hurt members of Congress who got in trouble as a result. And we certainly don't want that to happen here. So I look at Senator Respiccio's bill as a very enlightened piece of legislation that will help provide the rules of the game. Spells out how senators are to be approached by these representatives and what the procedures are, what they can and can't do, how they should register as lobbyists, and why they should register as lobbyists. Now, my personal hope is that in the future that we're not going to see the kinds of challenges that we see in state legislatures or in the United States Congress, and the resultant controversies that have come about, the national stories that have come about because of misbehavior by lobbyists. So far, we really haven't seen too much of that here, and I hope we will not see that in the future, and I think this bill will help limit that. As chair of the Committee on Standards and Ethics, or Ethics and Standards for the legislature, I wholeheartedly endorse this bill. And I look at it as another example of proper transparency when it comes to the work of the legislature. And it also puts the individuals in the community who are to be guided by this proposed law on notice as to how they are to conduct themselves if they should ever interact with this legislature. It's really time for this bill. I think that it speaks well of the 30th Guam Legislature. Should it be passed by this body and be signed into law? And I think it's a very good addition to our efforts to ensure that the conduct of this body is always at the highest level possible. Thank you very much, Madam Speaker.
Thank you, Senator Guthertz. On the motion, Vice Speaker, you recognize.
Madam Speaker, I rise in support of this legislation. It's about time that we have a full lobbying registration form in this legislature. It was through the legislation that Senator Guthertz, the preceding speaker, mentioned, that I was able to discover the tie between Jack Abramoff and the legislative effort in the U.S. Congress against the amendment to the Supreme Court Unification Act. And I just want to relate how that happened. I had retired from the bench because I knew at that time that, well, I probably shouldn't say this publicly, but I knew that this body didn't like me as the Chief Justice and would not pass the Judiciary Act with me sitting in the position as Chief Justice. But that did not mean that my efforts with your father and his efforts to get the Guam Supreme Court was going to just die because of some efforts to undermine the supremacy of the Supreme Court of Guam. And so even after I retired, I spent time in Washington, D.C. trying to discover who it was and why it was that there was this effort not to amend the law to make sure that we could have a Supreme Court that, as every other jurisdiction. And so I was in Washington, and I was told by Congressman Underwood's office at the time that it was Jack Abramoff through the Texas congressman that had defeated the bill. I had been assured by the chair of Judiciary that it was going to go through. And then it was submarined at the very last minute. And I tried to figure out what Jack Abramoff's relationship to Guam was and how. I went downstairs. I was in Congressman Underwood's office. I went downstairs to the lobby office, which sits in the rotunda in the basement. And I started to go through, and you have to be listed by name. And I looked at Jack's name, and I tried to figure out where it was and what the tie was. I looked, and I saw that Jack, I had heard, at least, that Jack Abramoff was a lobbyist for the Guam Airport Authority, and through a member of the legislature at the time. And I saw his name was there, but I couldn't figure out what that relationship was. So then I tried to figure out, just kept going through, and I saw that Jack's name was also tied to Mr. Hill, who I knew had previously practiced here on Guam, and I tried to figure out why Jack was representing Mr. Hill. So I looked at that lobbying registration form, and it said to lobby for reforms in the judiciary in the Pacific region. I immediately asked to pay for a photocopy of that and took it upstairs to Congressman Underwood and said there's a tie back. So I immediately called Guam. I called the Chief Justice at the time, and I said, find out from the governor why it is that this person who supposedly has registered as the lobbyist for the airport is also lobbying against our efforts to try to reform the judiciary. And I immediately got a call back that through discussions with the governor's office that though Jack had registered as a member to represent the Guam Airport Authority, he had in fact not received a contract and was not representing the airport, and so that couldn't have been the tie. But I was intrigued by this judiciary Western Pacific thing, so I brought it back, and at that time we still had investigative journalists practicing in the field of the news media. I took it to Arlene Steffi, and I said, Arlene, I need for you to follow this up for me and find out who it is and what it is in the judiciary how Mr. Hill is paying Mr. Abramoff, and or what this relationship is. And sure enough, Arlene went to the Guam Superior Court and asked for some documents and discovered that there were the series of payments that were made by the judiciary to, I shouldn't say the judiciary, by the Superior Court to Mr. Hill and Mr. Hill to Mr. Abramoff, and that's how that sweater started to unfurl. And so it's imperative that this piece of legislation go through so that at least we know who it is and why it is that people are pushing for certain things that are happening in this body and attempting to influence our deliberation. So this piece of legislation is an excellent piece of legislation. I commend the author. I'm embarrassed that I didn't think of it sooner myself, but I am in support of the legislation. But I want to bring something up, and I'm not necessarily making it as an amendment, but it's just something, food for thought. As you know, I just returned from the NCSL meeting in Louisville, Kentucky. And at the meeting was brought up a very interesting practice. In one of the jurisdictions, and I know that many of us will be like President Obama and refuse to unhook the morphine bracelet that we're attached to, our crackberries. But there is a jurisdiction in the States, at least one speaker, and I can't remember exactly. It was the ethics. I did an ethics meeting while I was at the NCSL, and one of the jurisdictions, I'd like to say that it was Virginia, but they have a rule where when they come to the floor for discussion and deliberation, they are not allowed to bring their BlackBerries to the floor because of the fact that members have been and were being texted while they were on the floor attempting to influence their vote. And it's ironic that we have in our rules that we allow former members of the legislature privilege of the floor, but we prohibit them from speaking to us about legislation that is currently before the body. But we have nothing in our rules that says that someone can contact us on the floor through text, through email, attempting to influence our vote on a piece of legislation. I bring that up to the body as something that we can think about. I know it hasn't been specifically heard, and I'm not ready at this time to offer it as an amendment, but I just want the body to think about it, that we do have a rule that specifically allows a human being to walk on the floor as a former member of this legislature, but we specifically prohibit he or her from speaking to us about legislation that's currently being discussed. But we have absolutely no problem with coming to the floor with our Blackberries, our iPhones, and our iPads and computers, and receiving live messages from people. They don't even have to be next door trying to influence our decision. They don't have to be on the floor trying to influence our decision. They can be sitting in some smoke-filled room trying to influence our decision by a text. It's food for thought. It was something that I heard at the ethics session at the National Center for State Legislatures. I'd just like for us to mull that over, and hopefully before we vote on this that we might be able to do something about that information. Thank you, Madam Speaker, and I commend the author for this very timely legislation. It's time, and I support the legislation.
Thank you very much, Vice Speaker. On the motion, Senator Pangilinan.
Thank you very much, Madam Speaker. Madam Speaker, I rise in support of this legislation, and I certainly agree with it, and believe that, it is in the public interest to ensure that when individuals are being paid to advocate for certain positions, that be disclosed. There was earlier piece of legislation, for example, on the campaign area, in which I placed greater restrictions on these individuals who try to influence the general public as well as members of the body by organizing groups and running ads and receiving money and spending money to advocate for or against issues that are presented before this body. And I commend and certainly thank the body before who implemented those regulations and put them in place and supported that bill I had in terms of campaign reform, all related to influencing members of this body. Unfortunately, Madam Speaker, individuals now who are raising money up to $1 million for their campaign have repealed or sponsored a repeal and supported the repeal of that legislation because they want to hide behind who's giving them money during their campaigns. And it's unfortunate that this body, I think you guys did it when I lost the election, in which they repealed those reforms that brings transparency on who's buying who with regards to their influence in terms of issues that are affected in this body or their ability to get into office. And this goes now a little further, I think, in terms of trying to bring that kind of transparency back. I certainly intend to resurrect those reforms within this body once again so that the general public knows that who is trying to gain access, because really that's what's involved, and it's the same whether in the political process, whether it's you try to gain access through money or you try to gain access through saying, well, I have a group of supporters, 50 of them, and if you don't vote for this, we're not going to vote for you. It's still trying to influence the behavior of members of the body on issues presented to us, where we're supposed to try and be dispassionate about it and base our decision on the public's interests and not our own personal interests, our own personal economic interests, or our own personal political interests. And I think that the repeal of those campaign reform and transparency laws have reinstated these things and the ability of these three things to influence members of our body. And so this at least brings clarity and transparency to individuals who are being paid to influence members of this body. But I wanted to make a couple of amendments, and one of them is very simple. And on line 9 of page 1, just to be clear, it is clear, but I wanted it to be absolutely clear that after the word defeat, so that line reads, influence the passage or defeat of any legislation including, and then it proceeds with a list. I wanted to just add to delete the word, or actually after passage, add the word content, no, after the word defeat, strike the word or out after passage and put a comma, so it would read influence the passage, comma, defeat, comma, or content of any legislation including, so that when you're providing alternate language in the bill that is already introduced, being discussed and heard, that it's not only the defeat or passage, but what's in the bill itself. And so I wanted that to be clear. It's kind of covered under A and B, but I wanted to be absolutely clear that trying to influence what is contained in the bill is also covered under actions taken by these lobbyists. So that would be the amendment I'm offering.
On the motion, there being no objection, so
the other amendment I wanted to make is this issue that you have to be paid above $1,000. I think if you're being paid, whether you're being paid $1 or $2, you should be covered and have to register as a lobbyist. What is the difference between a person who's being paid $200 and a person being paid $10,000? As long as they're being paid to influence this body, I think they need to register. And so I don't know what the threshold would be, but I just think that we should say that any person who engages for pay, right, so just for pay, so just strike out the word in the amount of, for any amount, or engages for any in-kind contribution, so strike out the $1,000 threshold. Right. And just say, as long as you're being paid, you really should disclose that you are being paid. On line 5, page 1.
So, can you read that again? Engages for any amount.
For any amount, strike out above $1,000.
For any amount and scratched out above $1,000. So it would read. Can you read then now the correct sentence? Lobbyists mean any person who engages for pay in any amount, then comma, and then continues.
Right.
Okay.
And then the $1,000 is stricken out again after that.
So on that amendment, Senator Spauldon.
Thank you, Madam Speaker. Madam Speaker, I've been listening very carefully to the discussion on the floor on this bill in general, and now that we're coming to this point where an amendment's being made where any amount, basically it could be as much as 1 cent, would qualify you as a lobbyist. And then if you really look at this legislation and look at other sections on page 4 under subsection E, public funds prohibited by a government entity. I guess the question I have is that when a group such as the Guam Chamber of Commerce, maybe the president of the Guam Chamber of Commerce comes in, or whoever they are, and they're paid a salary by the Guam Chamber of Commerce, right? And of course they come in to perhaps lobby, if that's the proper word, for certain things to happen. does this bill apply to them? Or say, for example, some of them GVB, of course, that being funded by government funds and whatnot, are they lobbyists? So would they need to, are they required then by this law to register and whatnot?
Yep.
You know,
So,
I'm not sure who to
Senator-
ask, Madam
Senator
Speaker.
Respicio, do you
Yeah, I
want
would yield to the
Yield
question.
to the question, okay.
In the first case, they will have to register because they're private sector and they're paid in any amount if this amendment passes. The second case, in the case of GVB, it says here specifically there would not be there would not be a lobbyist if they're a government if they're acting in their official capacity. So if the GVB board or the general manager of the Guam Visitors Bureau comes to this legislature and lobbies for legislation in their official capacity, then they would not be considered a lobbyist under these
But
provisions.
one of their consultants who might be working with the government agency who comes to speak to us to perhaps enact legislation or change the law or whatnot, they would be considered lobbyists?
They won't, because they'll be their source of it'll be government funded, so they will follow how they're being paid. It's only private money, yeah. But if the consultant is speaking on matters before the Guam Visitors Bureau, and they're a government consultant, then one would conclude that they're acting in that kind of capacity.
And I guess that brings us to the next question: who makes that determination?
It's right here in.
Page 2, line 13.
Would the government officials acting in their official capacity? You can,
Right. I mean, but are we saying that the government a
You can-
consultant who may be doing a project for the government then becomes a government official acting in their official capacity?
Then it'll be line 14, providing information.
Well, you know, and
they
again,
might also.
I'm asking this question because
They
there
might
are
be lobbying.
uncertainties in my own mind how this is going to work and how this all comes. I mean, because I believe in what, you know, what this bill is trying to accomplish, but now it's a matter of whether it can actually be carried out, enforced properly. Otherwise, we're going through this whole exercise, which might not have any real teeth to it, or, you know, any real enforcement arm to it, or anybody to make a real determination of whether one qualifies as a lobbyist or not. And I'm just wondering whose responsibility that would fall upon.
Senator Respicio, do you have anything else to add?
Well, it would be a function of the Committee on Rules, but the main, you would have to register with the Legislative Secretary, but I think between the Legislative Secretary's office, the Speaker, and the Committee on Rules, or any one member or the public can call attention that someone is acting as a lobbyist and not registered. The media may even bring these issues up, but I would imagine the Committee on Rules will be the one to enforce whether or not there's any infractions.
But say, for example, in a case where it's not so much that you can catch it, because if somebody doesn't register, we don't really know what if they were even a lobbyist or not. You understand, Madam Speaker, or my colleagues? And again, this is all more of a, in my mind, a logistical exercise in my mind, how this all come down. I mean, like I said, like in one instance where there is a contractor who's working for a government agency, of course he's being paid with government funds. Is he allowed? Because in this act it says that no government funds shall be expended for lobbying. And yet those are funds that are provided by the government to pay for this contractor, and yet he can't speak to the efforts that he's really trying to push forward on behalf of the government. So we're almost in a catch-22, at least in my mind, and if, you know, and I'm not really clear on how that all comes out in the wash. And if he doesn't register, how can we identify that he even is a lobbyist or not, and whether he or she would be subject to any penalties that we impose by this legislation? You know, and again, there's no clear. Like I said, I fully understand and appreciate the gravity of what this bill is trying to address, but at the same time, again, to make it workable, I'm just trying to figure out how do we really mold this legislation so it does have the effect on to address the intentions of this bill. Because if we go down this road and have no real clear direction on how this is going to be implemented in terms of issues that we have not really perhaps considered, again, the gray area, then, I'm not really sure how we go forward on this legislation. I mean, I guess one question would be right now is that we have some laws in place right now, and this is because it says this is to repeal and reenact this section of the law. And I believe that this section of law, as present in the books, does require for people to register as lobbyists. The question I suppose that needs to be asked right now is how many lobbyists have been registered?
None? that I know.
Zero. I mean, and I understand this law has been on the books perhaps since, I don't know, years and years and years.
Madam Speaker, I'll yield to that question if that's a
Yes.
question.
No, please. I'd be
And-
happy to hear the answer.
Senator Speaker, do you,
Yeah, the problem I'm presenting to the body and to the previous speaker, current speaker, is that this existing statute was enacted in the 13th Guam Legislature, and it's just very vague. It just simply means if you're lobbying the legislature, you have to register with the legislative secretary of the Guam Legislature. What we're doing in this bill, it spells out who's to be considered a lobbyist and who should not be considered a lobbyist, and it sets up those specific parameters. But because it's so vague, that's one reason why people
Nobody's
aren't
registered in essence,
yeah.
or three, including the good senator from Barragata, I understand, has registered as a lobbyist back in 1981.
But the gentleman brings up a good point, Madam Speaker, is what if you have a government consultant who is being paid for by government funds, comes into the legislature, takes for, in the case of the updating the transportation highway plan or some other master plan that they're working on. I don't know, one school of thought is that they shouldn't have to register because they're advocating for something to which their contract requires them to do. But another school of thought is, well, what if in the case of Jack Abramoff, where they're being paid for by court funds, and the court, half of the court wants to do one thing and the other half doesn't want to do the other. So I submit to the body that, if they were paid for government, and it'd be different if the consultant is lobbying the legislature for more funding to fund its contract. So logic will provide that, it looks like you're lobbying for your own contract rather than lobbying for those provisions and terms that your contract requires you to do. So that's how you would differentiate whether or not they're acting on their official capacity to say that we have to implement the Guam Master Plan and this is what we have to do in order to do that. Or if they come here and say, you need to appropriate $1 million to fund this contract, then that's a different story, I think.
Senator Espaldon,
Well, it still doesn't provide clear guidance, Madam Speaker, in terms of some of the issues. I mean, and I appreciate the answers, because I know we're all trying to figure out now, what all the what-ifs, right? Because we have to consider the what-ifs, the unintended, not so much the unintended consequences, but perhaps the unthought of scenarios in which we could actually become almost, again, part of that gray area where everybody just kind of shrugs their shoulders and says, well, I don't know. And I would, again, knowing the full intent of this and ultimately coming up, I mean, if we do pass this and then we try to live by the letter of the law, and in the end we all just kind of say, I don't know, that's not good enough at this point. I think the considerations and the discussions need to happen right now as we're moving forward on this bill, so that we don't end up in that situation where once we enact a bill or a law like this, we're not kind of like shrugging our shoulders saying, well, I don't know, we didn't think about that one. I mean, I think this is where we need to perhaps engage in the dialogue so that we try to imagine as many scenarios as possible that we already see before us today. Again, one scenario that I just presented was, again, a government consultant, right, who again, is paid by government funds, but now would under this law would be prohibited. for any amount. Now we're talking not even a threshold of $1,000. Now we're talking about even 1 penny counts towards that. And
Why don't
from
we,
coming-
can we take a brief recess here? 'Cause I see some other discussions going on, and I think it'd be important for us to just take this minute recess. session. As Senator Spaldon, you still have the floor.
Thank you, Madam Speaker. Madam Speaker, there were some issues that I raised before we went into a short recess, and I know that we have had conversations and many people are thinking about those issues that I raised. But since I'm only speaking on the amendment by the good senator from Barragata, and I know that we need to proceed on this matter, what I'll do is go ahead and I will not object to this amendment. But again, it just raised some questions in my mind, not so much the amendment itself, but for how we're going to implement this bill going forward. So I can speak to that once we get past this amendment, Madam Speaker. So at this point in time, I just want to thank you for the opportunity. Thank you.
Thank you very much, Senator Spaldon. Senator Pangilinan, you still have the floor, and I know there are several sections so whether you have the $1,000 mentioned. No, not yet, because he still has it to close on it and maybe clarify. What, you want to speak on that same? Yes, and that's where we're at. Because I don't have anybody else on the list on the amendment, so I'm calling back the mover of the amendment.
I'm done, Madam Speaker, on that first amendment that I presented.
But what about in line 6?
Yes, line 6 would also.
So
include it.
everywhere that will be a general.
Line 6, you would delete the words "in a value above $1,000."
So delete that.
Yeah.
And then on page 2, line 5 and 6.
That's line 2 would be another amendment, Madam Speaker.
Okay, so specifically then just for page 1, which is on line 5 and 6, for the deletion of the $1,000 and adding in.
Yeah,
Well, the first one is in any amount and delete in the amount of above 1,000.
Right.
Line 6 is in a value above 1,000 to delete. Is that
That's right.
clear?
And then I wanna-
on that amendment then, without any objections, so ordered. And then Senator Pangilinan, you still have the floor?
Yes, thank you very much, Madam Speaker. Then on line E, page 2, line E, I also want to just really prohibit lobbyists from paying expenses and amenities of legislatures. I just don't think it's appropriate. So that, you know, if a lobbyist wants to take you to lunch, you'd better pay for your own lunch. And so what this does is it really then forces the lobbyist. There's no incentive for the lobbyist to take you and wine and dine you. And really, he shouldn't. You shouldn't be subjected to that. A legislature shouldn't be subjected to that and tempted by that or influenced by that. And so I would just then delete on line, on page 5, I mean page 2, line 5, paying for any amenities or expenses of legislators, so that they can't be paying your expenses. They can't pay for your trip off island. They can't pay for a hotel room. They can't pay for lunch. They shouldn't. I would propose to this body that we shouldn't put ourselves in those kind of positions.
So it's paying for any amenities or expenses of legislators, period.
That's right. Or staff.
Or staff. Period. And then delete in any amount to
That's right.
the end. On the Pangilinan amendment, Senator Guthrie, you're recognized.
Thank you, Madam Speaker. You know, with this amendment, we're going to have to revise the Guam ethics law as it applies to the legislature, because there's a provision in there, and I remember Senator Pangilinan was instrumental in helping to get the ethics law passed for the legislature, which basically says that, I believe what it presently says, that anything of value of more than $200 may not be accepted by a member of the legislature or any government employee, for that matter, or official. When that bill was being developed, the ethics law was being developed, the original language, I remember because the students and I helped work on it at the university when I was full-time at the University of Guam, was what we call the 1 cent rule. that no public official in any capacity may accept anything in a value of more than 1 cent. It was called the 1 cent rule. So what I think what Senator Pangilinan is doing, which is good and I support it, is to again reiterate the need to set up these limits and limitations on things of value that may be brought to this body, whether it's a lunch or anything else. But if we approve this amendment, then we're going to have to update the Guam ethics law to reflect the same limit.
No, I don't, because this is for lobbyists. You know, in other words, the ethics law, if I'm...
One moment. Senator Guthers,
Yes.
Do you want to...
Yes, please,
to
Senator
yield to-
Pangilinan, if you wish to
okay.
clarify.
I just want to make sure. Okay, Senator Pangilinan, then please.
Thank you very much, Madam Speaker. Madam Speaker, I think that there's a distinction here between this individual and any member of the public who may give a public official a gift. So that if Tan Maria comes in and gives me a bag of fruit or betel nut or pugwa, she is giving me a gift as a member of the public, as an individual. The difference is if a lobbyist who's being paid to influence me is now giving me a gift, that's a huge difference. Because Tan Maria is giving me a gift in her personal capacity. This individual is being paid by someone to influence me, and so I shouldn't be receiving something of value from him, because it's his job to influence me to act in a certain manner on a certain issue. So I think this is not contrary to the ethics law, and it's like yourself, Madam Speaker. When a foreign dignitary comes and visits you, they give you a memento or a souvenir from their homeland, so that somebody from a Korean official comes in and gives you a scarf that's manufactured from the district that they represent, and that scarf has a value of $60 or $100. This doesn't prevent you from accepting that, because he's not trying to influence you. He's not lobbying you. It is from somebody who is trying to influence you, who really you shouldn't accept anything from. Because that can be construed as you trying to get you to act in some manner by giving you a gift. So that's the difference between the ethics law and this section of the bill, and I don't think they are contradictory if we reduce this to they just can't pay for your expenses or give you gifts.
And in return, I give a Guam Steel pin. Senator Guthers, are you done? Okay. Thank you very much, Senator Guthers. So, is there anybody else on the Pangilinan amendments? Oh, no, okay. Senator Rispisher, you recognize.
Oh, no, I'm still...
Well,
No,
no,
on the
not yet.
amendment.
We haven't finished this one. Yes.
Thank you, Madam Speaker. Madam Speaker, I don't have any real issues with the amendment, but for purposes of discussions and for the record, you can find something like this in the congressional, with what they do in Congress. The whole idea behind this bill is transparency. And some of the things that come to mind is because of the military buildup, what if there are companies or governments throughout Asia, maybe Japan, Taiwan, or Korea, that may want to invite certain senators on some kind of fact-finding mission? I don't know if this amendment passes, I don't know if senators would be prohibited from participating in those kinds of opportunities where you could see what the regional best practices are, and that's why I'm saying I'm struggling, because I don't have any problem with this, but there are some situations where, and it's happened in the past, where members of the legislature, any legislature, even the U.S. House and Senate, where they're taking on these kinds of trips, but they have to be filed and they have to be registered. And what I like about having to have these things registered is that you can now, because there's transparency, you can connect the dots between that member's action versus that how that member's action resulted as a result of interacting with that particular lobbyist. So I wonder then, my question is, if there's like we saw recently, the governor was able to assemble an entourage and go to the People's Republic of China. They went to Taiwan, and that was an economic mission. Would then something like that be prohibited?
Can you repeat that question, and maybe the mover of the amendment can respond?
Question is, if members of the legislature were invited by the government of Japan to Okinawa to do a fact-finding mission that's purely military build-up related, or any company that may invite some senators to go on a fact-finding mission to expose them to technologies that are being used in the region, whether or not there's, I guess the trigger would be if there's legislation or on the floor before that body, or if they want to introduce or they want to have amended somehow. But I think by deleting this amendment would be preventing members of the legislature from participating in those kinds of exchanges, because the whole idea is transparency, and as long as it's recorded, and as long as there's a threshold that certainly you don't want it more than $1,000. You don't want members of the legislature to be taken on a $10,000 fact-finding mission. So we thought that $1,000 would be a good threshold.
Senator McLennan, do you yield?
Thank you very much, Madam Speaker. If we were to kind of take a look at, because of the mention of congressional trips and so forth, there's a body of law, ethics law, and practices within the Congress right now. Members elected to Congress cannot accept trips paid for by foreign governments. So when the congressional delegations go to China, the Chinese government is prohibited from paying for the cost of that. They can go when it's sponsored by nonprofit groups, but again, that is strictly guarded and reported and determined. So under this statute, can a member of this body accept a paid trip by a foreign government to go visit their country to take a look at alternate fuel practices there, or an alternate fuel facility? I believe that they can. If a company who's trying to sell, if there's a legislation introduced in this body, and a company that to build an alternate energy plant on Guam, and a company that has an alternate energy plant in Taiwan wants to take you and show you theirs, I think that would be prohibited in that kind of fashion. If they're trying to influence you to pass that legislation, especially if it's tailored to their type of alternate energy. So I think we can look at guidance from what has happened, and while we may say that Congress is corrupt, this legislature is corrupt, whatever, in terms of the general public with regards to their dissatisfaction with government and the ethical behavior of government officials, we are seeing quite an active process in Congress now on the ethical behavior of its members. And so if we pass this and we have some questions and we need some greater clarification, we can take a look at what has occurred and what is in place in these other legislative bodies, and then make some amendments here. But a little roundabout way of responding to the question, I don't think it would prohibit us from accepting a fact-finding mission to a foreign government, except for maybe whether or not we run afoul of prohibition of government officials from accepting trips paid for by foreign governments by virtue of the fact that the government of Guam is a creature of Congress, and could we be construed as federal officials and be prohibited from accepting those? But I know that, we haven't in the past not accepted those. I think many of us have, or members of this body in the past, have gone on trade missions, fact-finding missions that may have been sponsored by the body. I think some members of this body accepted a trip to the Philippines under the overseas trade economic program that the government of the Philippines has, where they pay for the trips of private and public officials, private individual citizens, and public officials to come to the Philippines and take a look at that. Taiwan has done the same for members of this body. So I don't think that if that's the point, I don't think that that would be prohibited based upon what is being discussed in this proposed legislation.
Thank you very much, Madam Speaker. I appreciate that response, and I agree with that response. If in the event a foreign government wants to take us on a fact-finding mission, I would feel comfortable in participating in such a mission because that's being paid for by that government. But if in the event someone who wants to do business with the government, I would feel very, very uncomfortable in accepting a airfare ticket and expenses, hotel accommodations to go and see that individual's specific technology. And so I appreciate their response, and I agree with that response. And this amendment will make it clear that there's a dollar is a dollar too much. And so I support the amendment to remove in the amount above $1,000 per year.
Thank you very much, Senator Respicio. On the Pangilinan amendment, are there any other speakers? There being none, Senator Pangilinan, would you like to close, or you want me to just call for the vote? So there being no objection then to the amendment, so ordered. Senator Pangilinan, you still have the floor.
Final amendment, Madam Speaker. And that would be
Senators, please.
On page 4, to add a section B to page 4 under penalty. And so what that would mean would be to the current language in there would be labeled A and then add a B. And B would read fine. In addition to being prohibited from lobbying for the next 3 years, if any lobbyist should violate provisions of this proposed legislation, if passed, that there would be a fine associated with this. And that fine would be a fine equal to 5 times the fee or value of any in-kind compensation received by the lobbyist. So if they violate this, they're brought to trial or convicted or admit to it and so forth, that in addition to prohibiting them, that there would be a fine associated with that, and it would be 5 times their fee. And then the financial records shall be provided by the lobbyist to determine the fine to the appropriate government enforcement official.
On the amendment, are there anyone who would like to speak on it? Does everybody have a copy? Okay, so then it will be, so where it says penalty G, penalty, and then, okay, so, yeah, all right, so G1, the small I, and then the 2 small i's for fine. Okay, is there any discussion? So Senator Munya Barnes, are you okay? Okay, so on the amendment then, without any objection, so ordered. So now on the main motion, unless anybody else would like to, I have Senator Espadon on the main motion, and then Senator Palacios.
Thank you, Madam Speaker. I was wondering if the author would allow for a question. And the question would be going back to page 4, line 7, subsection E, concerning public funds prohibited. No public funds of any government entity can be expended to engage in lobbying. And the question is, this applies only to local lobbying. Is that true?
Senator, do you yield to the question, Senator Respicio?
Yeah, I believe that's correct.
Okay, so I mean, because it's just that earlier one of our colleagues spoke to, money that was spent in Washington D.C. for D.C. lobbyists, and so I just was wondering whether that really was, whether this section applies only locally in terms of no government funds locally can be spent for any local lobbying before this body, not necessarily prohibiting any lobbying in D.C., at least under this section of the law.
Because the gentleman is correct that the authorization for the governor to hire a lobbyist is covered under separate statute. And so he specifically authorized that he can have up to $1 million, but that $1 million must come from his existing budget. So but this one only applies for use of public funds for local lobbying efforts.
So are you going to proffer amendment to put no local public funds?
No, I think that it's perfectly clear by the answer, and I believe it's the correct answer, because this bill addresses lobbying to the legislature,
yeah.
the Guam legislature itself, not for any other lobbying outside outside the island, the jurisdiction of Guam. So I just wanted to make sure that my understanding was correct. Madam Speaker, also, I definitely support the intent of the bill, and although I have not decided on how I'm going to vote, and again, only because I still have some logistical and mechanical problems in my head in terms of how this all going to work out. I don't want to be, like I said, in support of legislation that, although the intent is good and we do put some safeguards in place and definitions in place, but ultimately really has no effect or enforcement power, or even it has no real authority cited as to who's going to make the determination of whether someone is in violation or somebody's even a lobbyist or somebody's even lobbying. It becomes problematic in my mind because, well, like I said, the intent is good, and yes, I definitely want to support this. I want to make sure that at least in my mind, that I'm comfortable that we're not just passing legislation that has no real mechanisms to make it effective. But with that, Madam Speaker, thank you.
Senator Espadon, on the motion, Senator Palacios, you're recognized.
Thank you, Madam Speaker. Just a simple, actually, amendment on page 2, line 7, and this is to be consistent with the amendment from the gentleman from Barrigada with line 1, or rather page 1 on line 9. And that is, of course, to where it says procuring goods and services from vendors in exchange for passage, defeat, or influencing the content of any legislation. And so that would be consistent, of course, with the previous amendment. That's the one thing that I noticed. And I think that is a very significant amendment to begin with, because that is really where the gist of lobbying occurs, is to amend or to influence the content of legislation. And I'd like to make that amendment. Just insert that. Thank you, Madam Speaker.
On the amendment, without any objections, and so ordered. Thank you. Is there anybody else who would like to speak on the main motion? Then Senator Respicio, you're recognized then to close.
Thank you very much, Madam Speaker. I'll be quick because I know we have 11:30 SES, but I rise to thank our colleagues for supporting Bill 383, which is a means of a real legislative reform, Madam Speaker. As I mentioned, that currently in the code, the only section relative to lobbyists just simply requires them to register with the legislative secretary. This code section, as I pointed out earlier, was enacted in the 13th Guam Legislature and hasn't been amended since. The current code is very simple and just simply states that a lobbyist is paid for his or her activities, but does not define specific behaviors that can be considered lobbying or define specific behaviors that are not considered lobbying. And the code section has been fairly useless, as it has been rarely used. I want to, just so that some senators who are still struggling as to whether to support this or not, I want to say that what Bill 383 sets up is, let's say, for example, you have, the question was asked by a good Senator, Tony Atta, what happens in the case of Mary Tory. Mary Tory has been recently engaging the legislature on a bill by Senator Titleweed that would provide for a transition to ultra-low sulfur diesel. In the case of Mary Tory, because she's paid by the Guam Hotel and Restaurant Association to lobby for that industry's efforts, in Mary Tory's case, she would have to be registered as a lobbyist because that's what she does. In the case of Dan Tidinko, who is handling public affairs for the Guam Telephone Authority, with the passage of this bill, and if it's signed into law, that individual would also have to register as a paid lobbyist, as well as other employees in the private sector that deal with public affairs matters, because that's their specific job title. But in the case of a general manager of the Hilton Hotel, or president of a beer company that's concerned with the bottle bill, if the president or management team of those companies come before the legislature to articulate their company's position, then they would not have to be a registered lobbyist because they're articulating their company's position. But if they hire counsel, or if they hire a public relations firm, or if they hire an individual, and it's very clear that that individual is hired to articulate that company's position, then certainly they would have to be a registered lobbyist. And so Bill 383 sets up all these mechanics. In the case of Senator Spaldon, who brought up a good point, what happens when you're a government consultant? Would you have to register to be a lobbyist? I want to, because it wasn't brought up in the course of the discussions, I want to offer as an amendment, and Senator Blas brought this up, Madam Speaker, that on line 13, page 2, that we add the words, after government officials, we add the words or designee. And so it's clear that if a consulting firm was hired to put a master plan together, part of their contract's deliverables would be to articulate that master plan until it's passed in the legislature, until it's signed by the governor or becomes the law of the land. That would be part of those consultants' duties and responsibilities. But just to make sure that they won't have to register as a lobbyist, under the section that says lobbyist and lobbying does not apply to, if we add the words or designee, so then you can have, as the example was brought up, GVB can identify who their consultants are and then come to the legislature to say that the TAF must be appropriated because we need more marketing in Japan or Korea or whatever their recommendations are. So that's my amendment that I'm offering, to insert the words or designee.
On the amendment, no objections, ordered.
Thank you, Madam Speaker, and thank you, colleagues. And
Please state your point of inquiry.
Thank you, Madam Speaker. It just occurred to me in the bill, Senator Spicio may want to make one more amendment, and that is to ensure that all of the records of the registry are public records.
Thank you, Senator Guthert. Senator Respicio, you still have the floor.
okay, I guess we can provide that. I could do that. So we add a new section that those that have been that have registered to be lobbyists of the legislature must be posted on the legislature's website.
It is on page 3, the last line, 20 and 21. All information submitted to the legislative secretary shall be placed on e-legislature and Guahan's website.
See, Senator Guthers, how fast we are. No, but they are, yeah, and shall be made available for public's review. Yeah.
And shall
Be made available
Be
for the
made
public's review.
available for public review.
In other words, what she's
Can
saying
you
is that
please-
this be available if anyone requested through the Open Government Law, the Freedom of Information Act.
Okay, so on that amendment, without any objection, so ordered.
But again, and to clarify regarding former legislators, Madam Speaker, certainly former senators are granted privilege of the floor, and they can lobby us while we're in here. But as soon as they accept money to become a lobbyist, that's when they're prohibited. So that's where you make the distinction. And just to clarify that, the other clarification is this enforceable? Certainly with the Speaker Pangilian's amendment, where we now have a fine, that puts some teeth into it. But the way you enforce something like this is you just ask someone at a public hearing, are you receiving any compensation specifically to lobby this particular issue before the legislature? And just like the law which requires anyone testifying before the legislature on financial matters that they be sworn under oath. I mean, that's something that we just had to have done ourselves. I myself forget that needs to be done, and every once in a while we help each other make those kinds of reminders. But the fact that Bill 383 is even being discussed in this legislature, Madam Speaker, under our term and under your leadership, just speaks to our commitment to want to reform the way in which we not only interact with the public, but the way in which the public interacts with us. And the information we're getting, there must be factual information, that we're not in any way misguided at all. So I thank our colleagues for their consideration. Madam Speaker, I thank you for your leadership, and I thank you for allowing me to deliberate and have discussions on this bill. Thank you.
To the third reading, file without any objection. You heard that, right? To send it 383 down to third reading, file without any objection, so ordered. We're going to take a lunch recess and also to attend the SES meeting next door. We will return at 2 o'clock this afternoon. The legislature is back in session. We are on Bill 418, and I recognize Senator Palacio.
Just say, Madam Speaker. Madam Speaker, Bill 418, of course, proposes to make.
A motion to place on third?
I move, Madam Speaker, that Bill 418 be placed on third reading file for purpose of discussion and perhaps placing on the voting file.
Yes, you may continue.
Thank you, Madam Speaker. Madam Speaker, Bill 418 proposes to, at the minimum, update the territorial parole board systems that we know now. The territorial parole board, Madam Speaker, was established by Public Law 7-49, and this is during the legislative term of 1962 and 1963, about 48 years ago. And it provides for a 5-member board, which is, of course, now known as the Territorial Parole Board. The board was never amended or revised, except at one time through Public Law 27-104, and which was a minor amendment, more or less administrative in nature, and that is barring elected officials from serving as a member of the board. That is the only amendment ever since. So much have changed in our penal institution and in the way the prisoners are treated over the last 48 years, Madam. Our Guam Penitentiary, for example, has evolved to what we call now as the Department of Corrections, incorporating into the penal philosophy the elements of corrections and rehabilitations, and not just punishment. Even our laws have evolved from what we used to call penal code, and then criminal correctional code, and now Guam Code annotated. The current parole board has not changed since first established, and is not in tune, in my observation, with the changes in contemporary penal philosophy. Currently, of course, the 5-member board consists of a chairman appointed directly by the governor and submitted his name here for confirmation. So if we confirm that nomination, automatically we're also confirming him as the chairman of the board. And the only statutory requirement for membership, this is provided in Section 85.10 is, and I quote, only persons who by their knowledge and experience are prepared to perform efficiently the duties of the board shall be eligible to such appointment. And there's nowhere in my research on the statute that established the parole board is given any specific definition or at least a baseline criteria of qualification other than that simple statement that persons who by their knowledge and experience are prepared to perform the duties of the board. Currently, the board that's made up today is 2 retired police officers, and that is in public record. Captain Dot Chagala, retired from the Guam Police Department, Lieutenant Connie Duenas, who at one time was the mayor of Batimuning, is also serving right now. And the chairman of the board is a retired DOC warden, who, by the way, was the losing party in the consent order, I think 13, 14 years ago on that civil rights violation, which I did to this date, the Department of Correction and the government of Guam continues to deal, and fortunately I understand that the consent order would be satisfied hopefully before the end of the year. But that is the chairman of the parole board, is the losing party, and I want to emphasize that, the losing party in this suit. And of course the other 2 comprise of, I understand, 1 teacher and 1, I would say, lay individual. It's a female. And again, my research did not show any quorum requirement, so they are guided by the standard practice of majority, so majority is 3. And so the bill, of course, provides for those things. The current issues right now, and this may not necessarily be true, the allegation of perception of inconsistency and favoritism by the board in parole hearing application or parole revocation. And this is due to a lack of what I would call internal procedures for the conduct of the parole hearing. It was so bad that I guess in the last 18 months, my office used to be visited frequently by Dr. Diane Strong, who is an advocate for inmate rights. And it came to my attention, of course, that there's just no internal rules and regulations. So when I introduced Bill 259 and put actually almost an ultimatum that if the board does not establish some basic rules and regulations, 6 months after the passage of what would be Bill 259, that any action of the board would be voided. I realized probably there should be a better alternative than that. So I have not pushed that. But out of that, a response came with the implementation of what was just one internal guideline, which is actually displayed on right here on the glass, would appear to be actually a procedure for the hearing of parole board application. There is concern that this probably did not comply with the AAA process. I guess there's been argument back and forth about that. The point is that because of that response, Bill 259, of course, was put into a hold, and then I came up with what I think would be a good policy, which is let us just recompose the board. So came of course, that's what led me to Bill 418. Bill 418, Madam Speaker, proposes to improve the current systems by, for example, adding 2 more members, increasing from 5 to 7, provide for a basic baseline minimum requirement, background and experience. For example, it provides that at least 2 will be in law enforcement or public safety position or retirement. That's already currently. At least 2 would be, I guess, in the areas of social worker, or which has to do with employment development and so forth, so that people that would be parole or would eventually be released will be prepared to have gainful employment. This is lacking in my research based on the current composition of the board. And of course, the bill also provides that the chairman be elected from among its members every 2 years. And on the powers of the board, section 85.26, I changed the may to shall, and the board shall promulgate rules and regulations for the conduct, of course, of its business, because without that, they say that at one time the response from the chairman at my request was that we don't need that because it's already very detailed in the statute. And I said this allegation of, again, is when does an applicant for parole can bring in someone that will testify in his favor, and when do you say no and when do you say yes? That's not in any writing anywhere. And I pointed out in the public hearing that maybe they are doing okay, but in the absence of established guidelines, there's really very little defense against allegation or against perception of unfairness or impropriety and so forth. So with this bill, Madam Speaker, I hope that with this bill, it is hoped, of course, that the inclusion of members with social service experience or education will provide for a balanced and fair debate in the deliberation of parole issues, whether to revoke a parole or to grant an individual a parole. The inclusion of members with social services experience will ensure the promulgation of policies that provide for proper, proper rehabilitation and eventual release from prison. We will provide for proper policies that will provide for the, for the preparation of the individual for successful release into the community. Madam Speaker, it was brought to during the public hearing that over 300 inmates, less than 25 are not eligible for parole. So you're talking that at least 300 one day will be released back to the community. With this fact, rehabilitation, of course, has become a major function of DOC. Now, over 300 inmates at any one time are eligible for parole. This bill, with the provision to include at least 2 members with social work or human resource experience, will provide for a fair deliberation during parole hearings. I'd like to point out that passage of Bill 418 would not affect the status of the current 5 members. They are already made the proposed recomposition of the board. They will not be affected at all. The committee has worked on this bill on and off during the last 18 months. The committee collaborated and received a written testimony from Dr. Kalingo, who is currently serving on some contractual basis with DOC for the rehabilitation programs and so forth. We received testimony, a written testimony and comments from Dr. Vivian Damis, who is a professor and teaches social work courses at the University of Guam. And we have received other comments and email on other things. Madam Speaker, this body received this morning email, or rather comments from a member of the parole board. And I reviewed those things. I took those things into consideration. You have received email. This body received email from Dr. Strong recommending for addition on amendments to the bills and so forth. Now, I presented my own research, my own work personally into this, my own collaboration. And I believe, Madam Speaker, that the information before us is sufficient to allow really for, to synthesize all this information and make a decision, considering, of course, that since its creation 40 years ago, the Territorial Parole Board has never undergone any change at all whatsoever. And I think that it's time this bill offers basic minimum amendment, but very substantial amendment, because the inclusion, just the inclusion of 2 additional members or 2 members to have a background in social work or human resource development or a clergy into there would be consistent with the thinking of rehabilitation, with the belief that people are amenable to change their behavior and conform with society standards. We need that to incorporate into the current board. My research and my observation has not have that adequately. Considering that of the 5, 3 retired from public safety. The whole orientation of public safety is to find the criminals and lock them up and throw away the key, so to speak. And so it's time, I believe, that the board be updated to be in sync with the changes in the penal philosophy, to put emphasis also, not just correcting and punishment, but on rehabilitation. Because these people, of that over 300, only 25 probably may not come out. The rest, and this has always been the history, will one day come out. Whether they're parole or not, they will come out in the end. And so they have to be prepared. I'd like to offer 3 amendments, Madam Speaker, to incorporate some of the comments or concerns and what appear to be the inadequacy of the bill, to just make sure that it's included. And then after that, I'm prepared to listen to other comments. If I may be allowed to make the 3 amendments, I know I number them 1, 2, and 3, so that we can conclude that. It's all passed out.
Yes, I hope everybody has a copy. It's 3 individual amendments, and on the top right-hand corner, 1, 2, and 3. So Senator Palacios, you may continue then with your first amendment.
Madam Speaker, I'd like to offer an amendment to line 19 on page 3, line 19. After the word study, and I just want to, I want to put a comma there and add, or any person with good moral character. This again now would allow the governor and the board to have among its membership a lay individual, an individual who just wants to have a decent life, minding their own business and live a good life, and not necessarily have to be really adverse in public safety or in medical and so forth, but just a common individual, a peer more or less of maybe one of those prisoners that will be coming before the hearings for parole application. So that will clarify that any person with good moral character, to extend that and include that as one of the item number 3.
On the Palacios amendment, is anyone who would like to speak on it? Senator Calvo and then Senator Pangilinan.
Yeah, thank you very much, Madam Speaker. Madam Speaker, I'm in favor in the intent of this bill, and I want to thank the author of the bill. But again, I know I think me and as well as maybe other senators may have received a correspondence from some of those that had interest in regards to this particular bill. And one of them was, again, Ms. Michelle Taituno, and she came by my office just yesterday, and that's why I didn't have an opportunity to talk to the author of this legislation, but she is a member of the Territorial Parole Board, and for whatever reasons, the members of the Territorial Parole Board were not aware of the public hearing. So with that, she brought out some of the issues that were involved, and one of them And I'm thinking,
Is it with the First Amendment? Are you addressing the First Amendment?
this is a letter drafted August
No,
10th.
I realize that, you're right.
Yeah, it deals with the First Amendment because my reference, there were issues that were brought forward in the letter that was sent to my office, and one of them deals with obviously the qualifications, and maybe if I could refer the question to the author of the amendment. In the issue dealing with those qualifications, as mentioned and indicated by Ms. Taitano, this amendment would add or any person with a good moral character. And I guess my question to the author of the amendment, was this the particular reason why this amendment is proffered, and is it in line with the issue and the questions brought forward by Ms. Taitano, and will it resolve the issues that were brought up in regards to the letter? And that is my question. With the author, I hope I can make the question any clearer. Is that particular to that issue brought up by the author of the letter?
Palacios, do you yield to the question?
Yes. Actually, it may not, but the fact of the matter is there is no qualifications right now. If you look at the statute 85.10, there's just no qualifications. And so since we are dealing with minimal baseline qualification, at least in the area of discipline, then one area of discipline, or if you can call it discipline, is lay representation. Mm-hmm. The other one is, of course, public safety or law enforcement representation. And the other one, of course, is maybe clergy or doctor or legal or somebody with that. And even if this were to pass, none of the five there now would be adversely affected. They would have met anyway the requirements. Mm-hmm. So really the only one single issue with Bill 418 is just to add two more, but these two more, please make it be social service background to incorporate into, so that rehabilitation work would be considered as an important facet in considering whether to grant parole or not. So this is because we're establishing the requirement or the minimum eligibility or qualification. I put that there, but it's always been there anyway by virtue of it not being anywhere else. So the government is not actually prevented right now from appointing anybody else. Yeah. In fact, I don't know, maybe a felon, or I don't know. The fact is, it's not lacking that.
Sure. Yeah. Thank you, Madam Speaker. Again, I have no problem with the amendment, but again, I just wanted to know whether that addressed the issues or one of the issues brought forward in the letter. So I have no problem with the amendment. Thank you very much, Madam Speaker.
Thank you, Senator Calvo. Senator Pangilinan, you're recognized on the amendment.
Thank you, Madam Speaker. I support the amendment. I just wanted to make an amendment to the amendment, and that is, rather than the word with, I think maybe it should be of, or any person of good moral character. So my amendment would be to replace with of.
Okay. So on that amendment, then to amend the amendment with the word off, to replace with the word off. With no objection, so ordered. Okay, so on the Palacios amendment that has been amended, are there any objections? No objections, so ordered. Thank you, Senator Palacios. Then amendment number 2.
Thank you, Madam Speaker. Amendment number 2, I would like to add and continue the sentence after on line 11, page 4. And this is, of course, to incorporate the concerns or the comments from one of the interested parties, or rather the parties concerned with this, that it shall be in accordance with open government law. And I think it should be. Right now, that's one of the major grievance, is that they have rules and regulations. We don't know when they're developed. At least this one, the public has an input. At the minimum, they can be heard whether they are considered or not. So add after the word duties, and shall be in accordance with the open government law. Notice that on that sentence beginning on line 9, which says the board may, Now I strike that on and shall adopt such rules and regulations, not inconsistent. This is of course the current provision, but then I want to add that and extend that so that we are for sure now. Because now I would envision that the board will be developing internal rules and regulations for its guidance. So that's my number 2.
On the second amendment, Senator Palacios' amendment to add the words after duties on page 4, line 11, and shall be in accordance with the open government law. Without any objections, so ordered. Senator Palacios, you may continue on amendment
Thank you,
number
Madam
3.
Speaker. Madam Speaker, my last amendment, again, this would just make sure on page 4, after line 3, add a new paragraph, of course, add a new paragraph still under the section. The election for chairman from among each member shall follow upon the expiration of the term of the current chairman. So that this way, if this bill were to pass, the chairman will still be good up until the current term expire. Then from there they will elect, so that it does not, again, Bill 8418 will not disturb the current arrangement at all. Who is the chairman will continue to be the chairman. Those that are there would still have met anyway the eligibility, or rather the baseline requirement. And so that is the amendment. The election for chairman from among its members shall follow upon the expiration of the term of the current chairman. I don't know.
On the amendment,
I think the inquiry is that when is the term expired? If that individual, we confirm him as the chairman, as a member and also chairman by request, I think it will just have to, when it expires, I guess. No, if this is a... Yeah, but I'm saying like that's why I add this last sentence, and it says, for the election of the chairman from amongst its members, it shall follow upon the expiration of the term of the current chairman. That's why amendment number 3, Mr. Speaker. So that clarifies that nice. So again, I don't want to disturb the current arrangement. That really the intention of 418 is to add 2 more with social service background or human relations background or clergy. Put it in there. The may replaced with shall, and then of course the chairmanship be elected among themselves when the current term expires of the current chairman. That's
okay.
my last
on the Palacios amendment, Senator Respicio.
Thank you very much, Madam Speaker. Madam Speaker, I certainly understand what the good mover of this amendment is trying to do, but I also understand that the way the chairman is currently appointed is by direct appointment of the governor. That the governor appoints someone to the position of chairman as a territorial parole board, or the Guam Parole Board. And so if we don't want to disrupt the current makeup, we might be preserving the current chairman's term beyond, because the reality is come January, we're going to have a new governor no matter how you slice it. We're going to have a new governor because our current governor is term limited. And so come January, already the current chairman is prepared that come January, he or she, in this case it's he will not be serving as chairman, because come January, the new governor would make that specific appointment. Of course, we know that during December, after the November election, and that election is certified, during that transitionary period, every single member of every single board and commission, with the exception of a few, like UOG, GCC, and a few others, they don't have to submit their courtesy resignations. But in this case, come January, we know that the new governor will make this kind of appointment. So what I would like to do is, if the author is willing, maybe just rather make it so that the current chairman is a chairman until December 31st of 2010. So come January 1st with the new board, you'd let these new members of this new board be able to elect their chairman. So I will not support the amendment as currently offered for that very reason.
Thank you, Senator Respicio. Anyone else wishing to speak on the amendment? If,
I amended the amendment. Unless the term of the current chairman ends December. Can we find out, Madam Speaker, when the current term ends?
we're going to go ahead and take a 1-minute recess to find out that answer. The legislature's back in session. Senator Respicio, you're still recognized.
Thank you very much, Madam Speaker. Madam Speaker, I didn't offer an amendment per se, but after discussing this with the author and some of our colleagues, just to be clear that if this bill is passed and signed into law, we want to get this board constituted as quickly as possible. And we already know that come January, traditionally, the way the case is that the governor submits a nomination to the legislature and he names the chair. What the author and the sponsor of this bill is attempting to do is to make the chairman be selected from among its members, so that there's no confusion as to when the chairman will be elected. There's some consensus, Madam Speaker, that I'd like to offer an amendment to this amendment, which will read, "The election for chairman from among its members shall follow upon enactment of this act." So once the board is constituted And if they want to retain the current chairman, then that's certainly their prerogative, and then I don't think that would be a problem. He's the current chairman.
So you would delete the...
I would delete the expiration of the term.
The
of
expiration of the
chairman.
term, right?
Yeah, of the current chairman. Delete all
Of the
that.
current chairman,
And
yes.
just say shall follow upon enactment of this act.
Upon enactment of this act. On that motion, are there any objections? No objection. Motion carries. Senator Respicio? On the main amendment? No. Okay. As amended. So on the main amendment, the Palacios amended, as amended by Senator Respicio, are there anyone else wishing to speak? If not, any objection? No objection, motion carries. Senator Guthert, you're recognized on the main bill, 418.
Thank you, Madam Speaker. I really like what we're doing with this bill. We're really making it a better bill, a more transparent board, and I appreciate the amendments that were made by the author and also Senator Respicio. I have one amendment, and this would be, Madam Speaker, to add a new Section 4 to Section 2A. I'm sorry, a new subsection 4 to Section 2A to read as follows. Nominations for candidates for parole board shall be received from the community, civic organizations, educational institutions, individuals, meaning anyone in the community, and village mayors. It shall be the responsibility of the Attorney General to publicly announce, receive, and to vet all nominees, and forward a list of qualified and interested candidates to the office of the governor from which to choose for appointment. The purpose of the amendment, Madam Speaker, is to really put in place a defined process in identifying potential candidates for this most important board, and to solicit the assistance of the Attorney General as the legal officer of the territory to receive the nominees after public announcement through the media, and to ensure that the nominees meet the criteria that is now being incorporated in Bill 418, and to forward the list of eligibles who've been nominated to the governor for consideration. Thank you very much, Madam Speaker.
On the amendment, anyone wishing to speak on the Guthert's amendment? No objection? No objection, motion carries. We're still on the main bill. Senator Respicio, you're recognized. And
Thank you very much, Madam Speaker. Madam Speaker, I rise to commend our good oversight chair, Senator Palacios, who has really taken a look at the current makeup of the parole board and to find ways to provide some kind of balance. As we know, nationally, the entire justice system has kind of moved from a more punitive terms of disciplinary against these individuals who have committed infractions in our community, but kind of moved toward, in some extreme cases, restorative justice. Restorative justice, where you give opportunity for the offender and those that were offended and the community to come together and have some kind of meaningful resolution to how they were victimized. And so you also give an opportunity for the offender to provide direct restitution to the victim. And that's what's happening on a national scale. We also know that with the juvenile justice system, the same can be said, where kids are going through a youth court or teen court programs rather than your traditional justice system. And when you take a look at the make of the parole board, I think it makes perfect sense to have social workers be part of that board so you can have some kind of a balance. A balance, not to say that it's going to be pro inmate, where that every single inmate that petitions the parole board will be granted parole. Because I've always said in my entire experiences here in the legislature that one of the more difficult boards to be on is probably the parole board. Because no matter what decision these commissioners make, someone will be happy, someone will be hurt, someone will be upset. And imagine if you're a family who has had 15, 20 years gone by, you never really lose what has been done to your family member, and then have to experience all this again, going through the parole process is very trying. So you have to have some kind of compassion no matter what. Whether it's certainly compassion for the victims' families and to recognize all the pain and suffering that they've had to endure over the years. But there also has to be some compassion to really determine if whether or not the inmate has spent the last 10, 15, 20 years making strides to rehabilitate themselves so that they can become productive members of our community. And I think that's what the justice system has been designed to do, and that's what it's set up for, so that you provide some kind of meaningful ways to make sure that this individual is rehabilitated properly. And if there's no remorse, and if they haven't been rehabilitated, then certainly they have no business going up for parole. But what I've heard, Madam Speaker, that's currently happening is it's just someone goes before the parole board, and the parole board has inconsistent applications in whether or not they want someone to defend their petition or just the opposite. Because there are no rules and regulations in place, they really can do things at whim. And I think what we're striving to do here in this bill, and this is why I support it wholeheartedly, is to require that rules and regs be adopted that will govern how their actions are. And in speaking with the author of the bill, you know, he's pointed out to us that the board currently, there's a statute that says the board may adopt such rules and procedures not inconsistent with law as it may deem proper and necessary to carry out its duties. But because of that word may, they haven't done it. So I know that the mover was already on the main bill. He's amended that to say they shall adopt such rules and procedures not inconsistent. And I know we just adopted his amendment, Senator Palash's amendment, that says, and shall be done in accordance with the open government law. I'd like to offer an amendment, Madam Speaker, and it's not to micromanage this rules and regs process, which really ultimately the legislature will be able to decide whether or not those rules and regs that were submitted to us encompasses this legislative policy. First of all, I don't like the idea or the fact that inmates are referred to as prisoners. And in this amendment, what I'm offering is it would encompass the amendment that we just adopted, kind of expand a little bit to say such rules and regulations shall include but not be limited to provisions of 5 GCA, Section 8103 and 8111, the open government law, use of the term inmate as opposed to prisoner, use of executive session for voting on applications, recusal of members due to conflicts, authorized presence of the media, access of inmate to pre-parole investigation reports, as well as design of the Department of Corrections as well as decision of the Department of Corrections whether supporting or not supporting parole, right of an inmate to have supporters present during the inmate's interview by the board, right of an inmate to have legal representation or other advisor present during the inmate's interview by the board, an attorney's right to address the board in the inmate's presence, right to receive minutes of the hearing as well as sound recordings, right to receive in writing specific reasons for parole denial and deficiencies to address in preparation for a future application, right to apply again in 6 months as mandated by 24 of the GARS subsection 2108, parentheses Parole Board Regulations 1997, which states inmates who have their parole application denied may reapply every 6 months, and finally, detailed description of an appeal process. And these are the things that I'd like this body to set as policy as the framework to which these rules and regs need to be built upon, as the foundation to which these rules and regs need to be built upon, so that if in the event that these rules and regs are adopted through the AAA process and done in accordance with the open government law, we can set one standard for all inmates who have to go up before the parole board, and so that all, because the way it is now, Madam Speaker, it's just sometimes the inmate can have an advocate for them based on the whim of the chairman or the parole board members, and sometimes they don't want to hear from anyone but the inmate. And so these will set specific guidelines and standards to which they would eventually have to build their rules and regs. So I offer this as an amendment. There's a part 2 here, but we can divide the question.
We'll divide the amendment. On the amendment, on the Respicio amendment, I'll recognize Senator Palacios.
Thank you, Madam Speaker. Madam Speaker, I rise in support of the first amendment, amendment number 1. I read everything. And these are the basic processes right now that are very lacking. These are the areas where inconsistencies or perception of inconsistencies or unfairness. Sometimes an inmate can bring in, for example, someone that will support him, and sometimes they don't allow that. I mean, that's why the lack of guidelines as to when do you allow and when you don't. It just raises a question on the integrity, of course, of the whole process. And again, there's just no reason why inmates who apply for parole cannot bring someone of their own choosing to just sit by their side. If nothing else, at least to give moral support. This is standard procedure in Government of Guam, disciplinary action, administrative action, that the employees are entitled to bring anybody of their own choosing. Again, they may not be lawyers, but they give moral support. They serve as good witness about what's going on. This is not happening regularly and consistently within the hearings of any board. So I wholeheartedly support, of course, this amendment. Thank you, Madam Speaker.
On the Respicio amendment.
On the Respicio amendment, Senator Taitigui.
Thank you, Madam Speaker. Madam Speaker, I was waiting for the opportunity actually to address this particular question, and I would like, I guess now that this amendment is put forth, the intention of it would be, if the good author would yield to a question that I have. This particular amendment, you know, Madam Speaker, my question would be simply, if an individual, let's say the board requests for the victim to come in to testify, and because, you know, all the trauma and all the things that they went through, trials and everything like that, you know, it becomes very traumatizing to that individual to basically relive the whole incident. But in the event that the board requests for a victim to come in to testify, and the victim feels that they would rather not have the inmate there during that testimony for fear of, you know, anxiety and all the stress and reliving the bad memory. So would this basically apply for the request of the victim when testifying in front of the board, not having the inmate in the room or the public or anyone else, and just the board itself?
Senator Respicio, do you yield to the question?
Does it require that the victims be subject to that?
I'm sorry.
This amendment will just set a standard for the inmates to have supporters present at the inmate's interview by the board. It doesn't talk about how the inmate has to be present when the victim's family is testifying.
Okay, then, Madam Speaker, I guess then it would be a question with regards to the open government law then in respect to that, and I will wait, and maybe the author of the bill itself can shed some light on that circumstances that may arise that allows the victim to be able to speak to the board if requested by the board to come and testify, that victim has some rights as well.
Senator Palacios, do you yield to the question?
Madam Speaker, I would not see any problem there. Again, that would be the exercise of the authority of the board. But that is why they have to have their own regulation and standards. When do they call in and why and under what circumstances? By the same token, the inmate applicant should have also the right to make presentation that is favorable to him. Because obviously when the presentation is made by the victim, it would be assumed that it would not be favorable. I don't foresee any problem there. It's only fair. It gives a balanced presentation of both sides. And that's the nice thing about that, is that eventually a decision will be a well-informed decision, incorporating those things. Yeah. There can be videotape presentation and those things. I guess the applicant might be momentarily excused. Those things, can be settled when we have policies which will be well thought out, before those things happen, of course. And that's why really the real need for policies.
Okay, I think most of it was answered. There is an issue with the open government law that may have, I guess the board may have the ruling to do that in their rules and regulations to be able to allow that to happen. And I thank the author for his work on this. I know he's been working very hard to get the board going along with the rules and regulations, the parole board. And I commend him for that. But Madam Speaker, I guess I'll save it for my closing when it's done. Thank you so much.
You're welcome, Senator Taitukui. On the, is there anybody else who would like to speak on the Respicia amendment? Senator Respicia.
Just to close quickly, Madam Speaker, thank you. In response to the concern of the previous speaker, there's a whole other set of laws that protect victims. And so if they want to even be videotaped so that you don't have to appear in person, or if the board wants to make accommodations where they would appear in person, but just the victim's family and the parole board members, and those accommodations must be made. So with this amendment, Madam Speaker, we're just requiring that there's be standards applied for not only one inmate, but all inmates, and that there's consistency.
Thank you very much, Senator Respicio. My understanding then is that there was a motion then to bifurcate this 1 and 2, so... No, the first one, yes. So we're going to do the first one. So all those then who are in favor of the first amendment, without any objections, no objections, and so ordered. For the new subsection number 2, all those in favor...
Oh, okay, I didn't speak, but just quickly,
I'm sorry, okay.
We're only requiring that it be subject to the open government law. This will make it clear that the adoption of the rules and regulations of the parole board must be subject to the AAA process.
Okay.
Thank you.
On that amendment, without any objections, so ordered. Okay, is there anyone who would like to speak on the main motion? Senator Guthrie, I'm sorry, did they hear your amendment here? Yes. Oh, he did. Okay, thank you. So on the main motion? Yes, on the bill, the main bill then. So Senator Calvo, you're recognized.
Yeah, thank you, Madam Speaker. Madam Speaker, first of all, I want to congratulate and thank the author of the bill for moving this forward. And though I do not have any issues of it, I think it may improve the situation with the territorial board. Again, I have to bring up the issue that has been presented to me by the good lady who is a member of the territorial parole board that did send a letter to me this morning, and I had an opportunity to read, and I just met her yesterday, and this is my concern, that again, there was a public hearing that was brought forward. I'm going to quote from the letters presented by the member of the territorial parole board. Although mandated by law to have a secretary for the territorial parole board, none exists. The Parole Services Division of the Department of Corrections serves as a secretary for the parole board. It has been and it is duty to inform parole board members of any and all, especially legal aspects concerning the board. Forgive us board members for our absence on July 8th, the day of this bill's public hearing. I've yet to know why board members were uninformed of the hearing. Present at the July 8th public hearing were members from the Department of Corrections, Director, current and retired corrections officer, inclusive the current manager of the Parole Services Division, and also a correction officer, and one person having an educational background and another in social work. Now, in summarizing the letter, again, Ms. Taitano brings forward some of the questions that she had, in particular to the bill, but then, of course, her major issues, of course, is that not being aware of the public hearing, and I do understand that this is made available, public hearing notices, to the media. But again, I thought it was custom that these notices would also be sent to vested parties or interest, and I am concerned that on a bill that deals with a territorial parole board, that it appears from this letter that none of the members of the board were there, and to that point, none of them were aware of the hearing, and I feel very nervous from moving forward, and I don't know, I'm not trying to delay this bill, but it is of importance. And with that, I would recommend to the author of the bill that whether we are to move towards having a committee of the whole, or this measure can be maybe moved towards the bottom of the second reading so that we can allow for members of the parole board to have discussions with the committee on this matter. And I'm not trying to be a roadblock. It's just that, again, this correspondence has come to me, and I do have my concerns, and how I move forward in whether I will vote yea or nay in the bill has a lot to do also with the input from the parole board. So again, I'm not going to make a motion, but I'm making this recommendation.
Senator Palacios, please state your point of information.
Madam Speaker, I assure my colleagues that not only did the committee comply with the open government law with respect to notices, as we have evidence of that, of course, in the committee report, but my office, I understand, is the only office that sends out this legislative alert. We actually fax directly to the parole board office if they receive it or not, or read it or not. Now, the bottom line is that the committee complied with all these notices. Aside from that, Madam Speaker, of course, there were people that attended that. And then it is not led to consider, I guess, the input this morning with respect to these things. But any further delay on this, like I pointed out in my opening remark, is that this body received enough information, of course, so that really the time really to act is now to improve upon the current system, which is very archaic. It's 48 years old. I never have any makeup or dress up or whatever they might call it. But again, the legislative alert went out. I have proof of that. And it's facts, and we have receipt of that. So they were adequately and sufficiently notified, whether they appear or not. You know, they can explain that to anybody else, but we have complied, and that's what I like to point out at this point, that there's no question about the integrity of the conduct of the public hearing, Madam Speaker.
Thank you very much, Senator Palacios, for that information.
Yes.
Senator Calvillo, you still have.
Thank you very much, Madam
continue.
Speaker. I'm not here to point fingers at anyone. I have a lot of respect for the author of the bill and the chairman of the committee. The fact of the matter is, and we have a letter here that was brought to me, and again, and it is a fact also that there were none present at the public hearing of the territorial board. And with that input, again, I guess I'm going to have to move forward based on either the input or lack of input thereof from members of the territorial board, and again, in particular, to an issue that deals with the territorial board form measure. But I want to thank the author of the bill for his hard work. Thank you.
On the main motion, is anybody else who would like to speak? Senator Taitagui.
Good afternoon, Madam Speaker. Madam Speaker, I too had great concerns over this particular bill, and I was present at the public hearing, and one concern I had was the fact that the board's composition was made up primarily of professionals. And Madam Speaker, when you go to any court hearing where a jury is selected, there are certain individuals who are exempt from being selected, and those are police officers, attorneys, those who are in the regarding with public safety. Now, Madam Speaker, this jury is usually appointed by its peers. And when you go into front of a parole board, that still should be a major consideration in the formulating of this board. Individuals of your peers out in the community. I'd like to thank the author of the bill to include a lane individual to be a part of that board. But that's such a small percentage. I have great concerns with regards to balancing out the authority to allow an individual to be set free who has not completed their term that was set forth by a judge. Rehabilitation, all the education, the ability to go back into the community and be a good part of our society and contribute. It's a difficult choice to make. But Madam Speaker, one concern that I had brought up during the public hearing, if we let inmates out early, do you really think they're going to be living next to an attorney, a person, a professional in that area, living right next door or moving in beside them? I don't think so, Madam Speaker. I really don't. They'll be living in areas where it's affordable, where an average person lives. But I don't think they'll be living next to attorneys or professionals, or what the bill basically says is a requirement to sit on the board to have that expertise in. So that was one of my greatest concerns with regards to that. And of course, earlier, as I mentioned, the ability for a victim to testify in front of a board. I guess when we go through these rules and adjudicate these rules and regulations, I will definitely stand up and make sure that that individual, the victim, has every opportunity to testify in a room where she is not going to feel intimidated or afraid to even walk into a room. I don't really think that videotaping or being able to, document this on a videotape is not less intimidating, Madam Speaker. Just being on the TV is intimidating alone, let alone being videotaped. So I'm going to make sure that I follow this thoroughly to make sure that piece of rules and regulations will allow the victims to feel at ease in coming forth and testifying. I do know there was a lot of work put into this, and I commend the author of the bill to wanting to move forward because it has been way too long. And but my concerns are still yet there with regards to the formulating of this board and its requirements. Thank you, Madam Speaker.
Thank you very much, Senator Titagui. Is there anybody else who would like to speak on the main motion? Senator Pangilinan.
Thank you, Mr. Dusmasi, Madam Speaker. Madam Speaker, I spent the last couple of hours, I guess, reading the committee report as well as the testimony and the bill itself, and of course following the amendments to the bill. And usually I kind of ask myself on proposals on things that would affect how things are now. And first question I ask is, what's the problem and what are we trying to fix? And I'm not sure, I couldn't get that answer by just reading the committee report. What spurred the need to make these changes in the current makeup of the board, number one? I mean, what is the philosophy behind the change in the makeup? Is now the philosophy that a board made up of these individuals with these kind of backgrounds is too hard on the individual, and it's too hard for inmates to get parole because of the nature of the background of the individuals who tend to be more hardline maybe? And so we want, is it unfair? Have we determined, and I meant, those proposing changes, have we determined that with that type of makeup, with that type of individuals on the board, that the system is unfair? That inmates that come before the board are not getting a fair shake? Is there bias? Is because we have law enforcement philosophy overweighted in the composition of the board, and therefore no inmate has a fair chance of getting parole? Is that the problem? And therefore we want to add the social workers to bring better balance or make it easier to get parole? Is that the problem we're trying to fix? I wasn't sure. I couldn't tell by the committee report or the presentations by those that came before the body. The one thing that I could certainly tell is that there's a lack of detail and written procedures that outline the process as well as the rights. That the parole board relies on statute to guide them in terms of how they receive, process, and act during parole hearings. And that the statute itself is more general than it should be, and therefore there's too much maybe leeway, or there's too much discretion in how these inmates who come before the board. So for example, the board, because of the lack of specificity in the statute, the board can decide to hear from a victim or not hear from a victim. The board has too much discretion in letting the inmate testify, not letting the inmate or the parolee applicant testify, and not letting him testify. And that's what we're trying to fix here. That's something that I think I can see very clearly from the presentation, that that is a concern that was brought up. And that is one of the issues we're trying to fix by requiring them to adopt rules and regulations pursuant to the open government law and subject to the AAA Act. And therefore, statute alone and the standard operating procedures of the parole division that services the parole board and provides the information and the application reports and to the parole board is not sufficient. Okay, so if that's the problem, then was there a need to change the composition of the board, or change the term, or make those changes? I'm not sure, and I'm sure that the good author in his closing will address some of these concerns. So that really, to me, is what it comes down to: is what do we desire to see in the parole board process that is not there now, that is a problem that needs to be changed and needs to be addressed. And the presentation that was made is the one problem is the lack of rules and regs that were subject to the AAA, so that everyone, including this body, can have input into, as well as the general public, for when they publish these rules and regs, part of the requirement, or propose these rules and regs, part of the AAA requirement is the public hearing process that will need to occur. And that the public and the community affected by the parole board and its processes and its powers will have an opportunity to make their input when the parole board itself or the Department of Corrections makes the presentation, and then again when it comes down to this body, and this body addresses the issue, and we conduct our own hearing on the proposed rules and regs. So I'm very comfortable with requiring that section being required and being proposed, and I can understand it in C. Now, the change in the makeup of the board, the change in the chairmanship, again, I'll go back and just articulate that I don't see what the philosophical change is in that is being made necessary by the current actions of the board. I didn't see, maybe I saw it in the one statistics that there's 300 applicants and 24 approvals, and we feel that's too low, and we want a different board with a different philosophy that will release inmates, that has a different approach to inmates who serve a portion of their time and become eligible, and that there's a greater diversity of opinion and philosophy towards the penal institution as well as the rehabilitative institution, and the considerations that they would make in order to grant these applicants parole. That we think that that's too low a percentage, and therefore if we add more social workers, and all of this is speculation, that if we add more social workers, they may be more, I guess the issue would be that there would be more bias towards the social and rehabilitative aspects of the system and the individual, and therefore maybe a bit more lenient or a bit more understanding, maybe is the proper word, to the inmates, and may decide then that they deserve a second chance, and therefore we're going to see more parole, and that's our goal here, is to allow more paroles given these considerations by these group of individuals, of course guided by statute then as well as rules and regulations. So I do see that. I see some of the concerns that are being addressed, and I just have to deal with some of what is being proposed. Is as far as the information I can gather, we'll continue to listen and see whether I agree with then those areas of the proposal. Thank you very much, Madam Speaker. Sidus Masi.
Thank you very much, Senator Pangilinan. So is there anybody else who would like to speak on Bill 418? So, none, so I would ask then the author if you would like to close.
Thank you, Madam Speaker. Of course, I was listening to the concern of the last speaker, and considering, of course, that the current situation is that there's actually not even basic baseline qualification standards, and I feel that since there's already nomination, there's already currently boards serving, then again, we will go ahead and continue and maintain that. We just have to put the definition into that, and that's why I say Bill 418 would not disturb that. I think if you look at Bill 418, Madam Speaker, it's more or less, there's nothing, not so much that we need to change the composition, but more so to add two more. I believe that the additional of two members with social service background would be more amenable, I guess, to now putting an emphasis also in considering the rehabilitation program completed by the inmate applicant, as opposed to just the punishment that's already served. Again, this is not to take away what there is already established, but to add on to more. There is the perception that because the majority of the current member, the board, which is 3 out of 5, actually retired professional law enforcement and public safety individuals, whose actually the entire career indoctrination is catching the criminals and throw away the key, so to speak, of course, appear to maybe not necessarily favor granting or be very receptive in approving application for parole. But with the social service worker in there deliberating on the issues and so forth, there will be emphasis on the fact that this individual has come a long way, is ready to rejoin society, to the community, and is trained, had accomplished this work release program well, no conduct, no misconduct, no demerit during this period, and is ready to come out and to serve in the community and be one of us. And that really is, if nothing else, that is the essence of the recomposition. And since we are at it, might as well establish some kind of baseline standard qualifications requirement, because right now there is none. So anybody at all may be a member of the Territorial Parole Board, even though right now we have professionals in there, and it will be like that, even with the passage of Bill 18. Again, Bill 18, I like to emphasize that it only proposes 3 things: add 2 more with social service background, discipline in education or in experience, work development program specialists, things like that, because these are very crucial for the individual who eventually will come out to the community to join us. They have to be prepared to work well, to know about work ethics, and to find gainful employment. And then the other 2 points actually of Bill 418 is to require the board, not just may, but shall develop rules and regulations for the conduct of its, and then of course to elect among themselves their own chairman, as is the standard practice actually throughout this government. And with respect to certain discipline requirement, like public safety discipline or social service discipline, I remember, in the 6 years that I've been here, that this legislature had considered some composition of boards, that they have to have certain background. For example, Board of Education or the regions, that they have to have this, they have to have that. The idea that they have to have a certain expertise in certain discipline is actually, that is the idea in Bill 418, and not so much that it is mandatory, but that concept that people in law enforcement should also be mindful that, hey, you have done it before, wait a minute, maybe you're not ready yet. So you need that balance. And then, but the social worker said, this person had done it. The psychologist said, his mind is stable. The crime community was 19, now he's 40. I mean, there's those kind of arguments. It just put in a positive dynamic in the workings of the board, if we were to have these 2 additional kind of discipline in there. And this would be put in statute so that there is some minimum, baseline qualification standard to serve in the board. And then you have the 3 others out of 7. The 3 others would be actually anybody with of good moral character, which is a lay individual. So that is actually, and I hope that I work on this directly with people involved in here, the social service worker, Professor Vivian Dames. I want to repeat that. In fact, at one time, I offered actually a workspace to Dr. Diane Strong, who is really very much passionate about these things. I offered her a workspace in my office as a voluntary, and sadly she declined. But that's how I get involved, and I get to know the detailed workings and what's going on. And again, the current situation is just because, I guess, the lack of, that's the primary issue really, is the lack of guidance and internal guidelines and policies, which lead to allegation of perception of inconsistency and unfairness. I'd like to emphasize in closing, though, that Bill 418 will not alter the current 5-member board in their own current status. Nothing at all like that. It would not change the selection process. It would just add to more additional membership into it and set some minimum criteria. And I hope my colleagues will trust that the bill had gotten a good, really a good research into it with wide participation of experts, psychologists into it. And I hope that my colleagues would consider supporting Bill 418. Thank you, Madam Speaker. And I move that Bill 418 be put on the reading file for voting.
No objection, okay. We've just finished Bill number 418. We will now move to Bill number 413. Speaker Wampat. Bill 418 is placed on third reading. Senator, thank you. I do apologize, Senator. Again, Speaker Wampat, you're recognized.
Day, Madam Speaker. Okay, I got take my breath back here. I'd like to make a motion to place Bill 413-30 in the third reading file, and if I could just briefly explain what it is.
Is that an amended version? I don't have a copy.
Oh yes, I'm sorry. As substituted by the Committee on Economic Development, Health and Human Services and Judiciary. Maybe the chairman, of course.
Speaker, does everybody have a copy of that bill?
Oh, I took the copy from up there. I'm so sorry. We need to give you one.
Oh, Benjamin's going to give you a copy.
Thank you. Okay. Speaker Wampat, you can proceed. I do have a copy now.
Okay, thank you very much again, Madam Speaker. Madam Speaker, just to give you a brief, I guess, description of, where we were with 413 and where we are today, and that's why it was heavily substituted, because it started out to actually set a cap for JFK and for a new northern high school. And as a result of a meeting that we had with the Municipal Planning Council of Dededo, and with the parents there as well in the vicinity where the site was going to be, a specific site where the sports complex facility is at, that the space owned by Parks and Rec was going to be the site for Northern High School, and the families in the vicinity felt that the area is so congested today, and that it will be compounded even more when a new high school is developed there. The chairman, the good chairman from Jonia, had a public hearing. The same individuals who spoke that evening were present that day as well, and provided some input. The decision of the community of Dededo, and in speaking with the officials from the Department of Education, that they felt that instead of having to go in then and build a totally new structure in an area that they feel would cause more congestion for the community who lives there, was that to actually go to Okadu High School and extend or expand the high school now to be able to take on more students. That meant, of course, that we would have to increase the population of that school, because as you know, for high schools right now it's at 1,200. We've allowed all the existing schools to continue with their current population up to the number of 2,200 students in our high schools. But in order then to expand Okadu High School, it would mean then that we would have to amend several things. The whole purpose of this expansion, or even the thought of having another school there to address the overpopulation in our northern schools, is that we needed then to expand a facility, if not build a new facility, but to expand. The legislature then in this case would have to authorize then the government then to enter into a contract for the financing, design, construction, and long-term capital maintenance of this additional improvement to Okudu High School. This is a substitute of a new Northern High School, and this would also then take advantage of a facility, an existing facility, where there is already infrastructure, there is an athletic facility, and then so this would end up being more of a savings to the government than going in and building a whole new high school. The several things that would need to be done, Madam Speaker, with this expansion of this school is to try to take advantage, because it's only limited to $2.9 million out of the 9.8 that was originally designed or reserved for 5 projects. We are now really down to 2. The JFK High School will take the bulk of that money at 6.9, and the remainder then will be 2.9 for the expansion of classrooms, restroom facilities in the outdoor sports fields, additional restrooms to make sure that we comply with the 14 points, solar panels. A culinary arts in a high school was never put in, so that will be important to build that. Signalization just before the entrance of the school, because there is now, as you know, there are 4 lanes, 2 on each side, and now they've actually, towards the entrance of the school, would have to take the center, one of the lanes, I'm sorry, going out of NCS, and signalization is important to have there to be able to control the traffic in and out of the school. It would also then improve on the track and field with a proper turf to purchase the additional equipment for the additional classrooms that will be built at the site, at the Okudu site. What makes this important to do at this time, and time is really critical here, is because Guam then is actually able then to receive monies from the American Recovery and Reinvestment Act of 2009. We are authorized then, the government of Guam is authorized to issue a total of $21.8 million in what we call the qualified school construction bonds to be able to help to assist to finance the construction, rehabilitation, or a repair of public school facilities. This would also mean that we have to have a project in which there is, almost like a shovel-ready project, and because the current contractor who actually has built the Okudu High School is the exact same contractor that was actually given the contract for the Marlboro site, and as you all know, that site cannot be used for a high school or any school facility because it is in an area where there are so many water wells, but worse yet is that it did not fall into the hands of the government where maybe can be part of the GWA inventory. The military is actually now taking that Marlboro site back because the government has not done anything on the site for so many years. So it is important then that now we find another place, and we've identified a place through GDOE and the community and the mayor and the mayor's council that we look to Okudu High School. Now, since we have all these things in place, one, the contractor 2, we've identified the facility. 3, we've identified the funding source. And 4 is to be able to get additional funds, ARA monies, in the QSCBs, the Qualified School Construction Bonds, that we would need to move forward on this as quickly as we can through this legislation. Then it will lock in the $10.9 million for this fiscal year, and then another 10.9 for next fiscal year. So by locking this in September, but the work that can be done towards the end of the year, then we would be able to meet the timelines to secure not just only this year's funding, but also next year's funding. So I'm hoping that my colleagues who were there at the meeting at Dededo were also here at the time when we were going through the finalization of building and having JFK move forward, that we also move forward with this as well, so we can alleviate the overcrowding in our high schools is at the northern site. JFK, we know, is at over 2,200. We also know GW is also over 2,200. Simon Sanchez is close to 2,000. Okudu right now is beyond 1,200. They're at 1,300 and growing. And with the expansion of Okudu High School, then we might be able to alleviate some of the overcrowding in north, central north, and on both sides from JFK and GW to start to fill the students at the Okudu site. This, Mr. Speaker, is not going to address the total needs of our students, our student population up north. It's not just a high school that we're looking at, because this is not we're not building another new northern high school, which is, probably somewhere down the line in the future that we might have to consider, again, another high school. I do know that there is a great need to have another middle school and even an elementary school. Unfortunately, it's not so much that there are new students coming on island, because our school population, at least when I was in the system, was at 33,000 students. We really are at 30,000, but what is happening is that we're seeing the numbers, our own students migrate from the south central to the north, and we're seeing our school populations in the south start to drop. Our southern high school also is not at capacity. And I know the superintendent was actually talking about, having a different program there, that maybe children from the other school districts would be willing to come there if there's a concentration maybe of, a certain career path or educational path, similar to the STEM that GW is preparing itself to implement, and that's the Science, Technology, Engineering, and Math program, because of its proximity to the University of Guam and Guam Community College. Until such time that we're able to maximize our full capacity of the Southern High School, we definitely need to take steps to be able to house the overcrowding of our other high schools into an extended or an expanded facility at Okudu High School. I just hope then that our colleagues would consider, the need then to be able to pass this legislation. Part of the language here was actually language that Bond Council was able to provide to make sure then, because the funding source that we were considering is the same funding source that is being used for the JFK rebuild. Thank you very much, Mr. Speaker.
Thank you, Madam Speaker. On the motion, any senators wish to be heard? I was relieved. Senator Agan.
Thank you very much, Mr. Speaker. Good afternoon. Buenas and Afade. Mr. Speaker, I stand in support of this proposal. I think that when you take a look at the process that has transpired over the course of the last several weeks since the introduction, it's more or less clearing up an action or closing up the gap in terms of the action of this legislative body during the special session that was held last week. If you recall, there was an emergency session, if it was last week or the prior week, where in fact legislation was introduced to address the JFK situation. Well, incidentally, as part of that legislation, the allocation of the $9.8 million, which was previously solely dedicated to the JFK Reconstruction High School, was segregated. It was that particular figure for JFK was reduced to 6.9 with the available amount, the remaining balance of about, I believe, 2.9 was made available specifically for the expansion of the Okudu High School, and that's highlighted in Public Law 30-178. What this legislation does, it is the accompanying provision that provides the expanded opportunities or possibilities in terms of being able to utilize those proceeds which will become available after 2011, specifically to allow this government to look at financing the expansion of the existing facility over at Okudu High School. And in that regard, I believe the sponsor, the good speaker, also mentioned that the other part of this entire option is that it would provide the community an opportunity to be able to access some ARA funds / USDA proceeds, if in fact that's the place of origination, or the USDOE. It would allow for the acquisition of some additional funds up to $21+ million, specifically for the projects that are highlighted here in this particular legislation. So, Mr. Speaker, when you look at this and you look at the nature of the allocation of the resources, this is already identified in a previously enacted legislation that was signed into law recently, and it's just more or less putting in the accompanying verbiage so that in fact the government of Guam has the parameters in terms of how to expand the additional $2.9 billion and expend those resources towards accomplishing some of the items that are identified here. We look at the original legislation, which had identified a parcel of property in the north and had also moved in the direction of identifying funding specifically to allow the government of Guam to go out and borrow money. That has transitioned to what it is today in terms of being more or less the verbiage that is being provided in terms of allowing the government of Guam to access the up to $21+ million from ARA, and then also utilizing the additional identified Section 30 proceeds specifically for the repayment of that particular loan. So in this case, Mr. Speaker, we look at these and it's specific in nature, use of qualified school construction bond funds, the pledge of the resources, like I just mentioned, out of the Section 30. It's not more or less because my committee really has very little jurisdiction in terms of outrightly committing Section 30 funds without having to go through the Finance Committee. But this highlights that in fact these proceeds, the $2.9 million was previously identified in previous law, specifically for the expansion of the Okudu High School. So outside of that, Mr. Speaker, I think it's a very timely legislation. They were looking at the conclusion of this month of August, and obviously we're already on the 11th day of August, that the ARA funds would need some form of commitment in terms of being able to meet the repayment obligation on the part of the bonds. And that's what this would provide, and I anticipate that upon the passage and the signing of this particular legislation into law, that it would allow the government of Guam to be able to go out and immediately set aside those proceeds, whether they're broken up into fiscal year 10 or fiscal year 11. At least those proceeds will be readily available, set aside specifically for the projects that are highlighted here. The only one concern that I do have, Mr. Speaker, and the good speaker had mentioned about the construction of a traffic signalization system outside of the school. And you know, Mr. Speaker, repeatedly over the course of the last several years, I believe our colleague to my immediate left, or to my left, has more than 2 or 3 occasions had raised that, and also you had raised it on a couple of occasions about putting in a traffic signalization or providing appropriate accommodations for the individuals that are going into that particular school facility and those who are exiting Okudu High School. Well, we're into perhaps a year and a half of the completion, or a little bit more of the completion and the use of that high school, but we have yet to see any physical construction towards providing the necessary accommodations. And I think that it's presented some tremendous challenge in terms of the traffic flow. Mr. Speaker, I don't know if you've ever been there during the course of the morning shift or during the rush hour in the afternoon, but it's caused a tremendous amount of traffic congestion just in that area during that hour and a half time frame. And I think it's unfortunate that, in fact, that particular project had not been completed or is not underway, but we have received assurances on more than one occasion that, in fact, the funds were identified and that was part of the overall master plan to be completed within the next year and a half, and in terms of that project being completed within the next year and a half out of the federal highway funds. So, Mr. Speaker, I don't know if the good speaker would be amenable to making an adjustment in terms of the allocation and the use of these proceeds, because the traffic signalization, if it will be paid by federal highway funds, perhaps it would be best if we can use all of the proceeds in here specifically for school construction activities rather than the traffic signalization. So I'm still looking for that particular language, Mr. Speaker, in terms of where it is identified, but if in fact it's specific, I was told it's in Public Law 30-178, but in that particular case, Mr. Speaker, I really don't think that it's an obligation on the part of education-related facilities funding to be able to look at the traffic signalization. I understand the intent of the good speaker and the author of this legislation to try to look at expediting that as quickly as possible. But if in fact, after the assurances that yourself as well as our colleague to my left has received repeatedly that in fact the resources and the funding is readily available under the federal highway projects, and that will be completed within the next year and a half, then perhaps it will be best if in fact that not be part of the requisite or the requirement or the use of some of these proceeds. I understand it may be in the public law itself, and I certainly would like to encourage the sponsor of the legislation to look at perhaps extracting that portion so that in fact those funds can be specifically utilized for other school-related facility projects or other costs associated with this particular school construction bond. So that would be. I was told it's in Public Law 30-178, and it's not in this particular proposal as we speak. So, Mr. Speaker, then let me just ask if by any chance I can be given the flexibility to come back a little later just to entertain that particular amendment for consideration by this body, Mr. Speaker. But other than that, I stand in full support of this, and I commend the Speaker and the members of the body who have sponsored this legislation, because I think it's very timely. You're looking at the northern high school population reaching, I believe, Okudu High School has already reached a level of 1,700. All of our other high schools, when you look at JFK, 2,400, you look at GW, 2,200. I mean, obviously, in this particular case, we may need to try to shift some of our student population so that, in fact, it's a little bit more accommodating. And I believe that expanding Okudu, at least for the foreseeable 2 to 3 years, will be able to address this while we as a community work aggressively towards the construction of a whole new northern high school. Thank you very much, Mr. Speaker, and if I can ask for that flexibility, please.
Of course, Senator Argan, you will be allowed to come back to the floor to address that one issue or any other issue that will improve this bill. I believe, Senator Muñoz-Barnes, you have a point, or you wish to address this motion?
Yes, I do. Sidos Masi, Mr. Speaker, and thank you for giving me the opportunity to rise in support of this bill 413-30 COR as substituted by the committee. And I'd like to thank the oversight chair on the Committee of Economic Development, Health, Human Services, and Judiciary for taking the time to work closely with the author of this legislation to assure that this bill will be placed on the agenda today, and making sure that the committee report was prepared. I'd like to make, before I go on, I'd like to make a couple of motions and corrections, if I may. And my first one will be to add my good brother from Barrigada, Frank Blosh Jr., to be added to the sponsorship. If there's no...
Without any objection?
The second one, Mr. Mr. Speaker, is on line 16 on line 16 on page 2. If you can correct that word after the word off and just put public on it. If you can, please. Can you just please correct that word, sir, and make sure that the right spelling of public is inserted in there?
How's it spelled, Senator Munya Barnes? Currently?
Please. Mr. Speaker. Mr. Speaker.
I want to go to school there.
It is spelled P-U-B-I-C, and public is spelled P-U-B-L-I-C. Please, Mr. Speaker, if I may. I do apologize to my colleagues, but can we please make that technical correction?
Please.
You guys are bad. I fell into that. And also on page 6, Mr. Speaker, line 9, after the word responsible, if we can please correct for F-O-R instead of F-O-E. Line 9. God.
Without objection, both.
Okay, Mr. Speaker. And Mr. Speaker, if I may, I just, maybe just for clarification's sake, and maybe the good author could help me out here. On page 2, as we look at the responsible party and how this would fall under, it says this authorization is intended to substitute in part the facility needs to the new Northern High School to the existing land under the lease to the Guam Department of Education, which is Guam GOD. But on line 9, it also allows it for the education agency. And then under definitions on page 4, line 15, the education agency shall mean the Guam Public School System. And I know, and I think I'd like to just make the general motion. I think if I'm correct, that would be now the Guam Department of Education. And unless this,
There being no objections, all those amendments shall be ordered.
okay. Si Diyos Masi, Mr. Speaker. And Mr. Speaker, what page? What page? Page 4. Oh,
One's
if I
italic and
can,
one
also on page 4, Mr. Speaker. Okay? Okay. Again, Mr. Speaker, I just want to thank the author for giving me the opportunity to be a part of this legislation, as we truly believe that as we look at the overcrowding of our school and the true need for making sure that the students that are within the northern area got a place to go where, and that knowing that expanding this school will help ease that overcrowding burden, It truly is a win-win for the northern community for this high school, and also being able to address the facility, the culinary facility, and also knowing that we can, that with this passing of this legislation, that the qualified school construction bonds funding, the QSCBs will be afforded us to help assist in the building of this facility. When we get that additional resource that is gravely needed for the education department, Mr. Speaker, it becomes a plus for the Guam Department of Education. And when we look at the grants to be over 21.8 million, then we know that if we don't take the opportunity to jump on that bandwagon to ascertain that grant funding, then it doesn't become a win for not just for the education department, but for the children in general. And again, knowing that we have realized that the process that we have gone through, that this municipal lease to construct this expansion, knowing that we've already done this before, again, just goes to show that we will finally realize that the overcrowding of the schools in the northern area will be eased. So again, Mr. Speaker, I just want to ask my colleagues to share in the support of passing this legislation, and I'd like to thank all the members who have jumped on the bandwagon to help support and move this effort offered, as it continues to be a collaborative effort working closely with the administration and this body. So thank you.
Thank you, Senator Muñoz-Barnes. Any other senators wish to be heard on this bill? Senator Espaldon?
Thank you, Mr. Speaker. Mr. Speaker, I rise in full support of this of Bill number 413, and this is definitely necessary at this time. We all can acknowledge what's going to be happening over the next several years, and this is more in line with forward thinking on the part of the government. We also know that there is definitely a need for more school facilities on this island, especially up north, where the new population that we anticipate will be moving to. Right now, with the new, even though Okado is a brand new school, it has reached its maximum capacity, and that's without the movement of new population base coming into Guam. So this is actually forward thinking in anticipation of the educational needs of the students going forward. On top of it, the type of funding that is going to be used for this actually is, again, very beneficial in this case, in that when we start talking about the qualified school construction bonds, this is definitely a good way to finance it. Even though it is a bond in which we would have to repay, it carries no interest, if I understand this financing option properly. And again, that represents a cost savings, where if we don't use these bonds now, or this method of financing right now, we may never be able to access this kind of financing again. The ARA funding, under ARA, again, this is a very limited time frame in which these kind of financing methods can be used. So if we don't take advantage of the opportunity, then we will definitely see an increase in costs should we down the road expect or look forward to expanding Okado or building other facilities up north. Bottom line is, there is a need, there is a way, and there is definitely now a bill to address that need and to ratify the way. So I stand in full support of the expansion of Okado High School in Northern Guam. Thank you, Mr. Speaker.
Thank you very much, Senator Espaldon. Any other senators wish to be heard on Bill 413? Senator Teidig, will you recognized?
Thank you, Mr. Chair. Mr. Chair, I stand in full support of this measure that would help the residents in the northern part of Guam. You know, their their capacity is already busting at the seams, and even other areas too as well. And maybe I shouldn't have said busting at the seams, but anyways, Mr. Speaker, I'd like to ask the author if she can yield to a question I have.
Madam Speaker, do you yield?
Okay.
Please proceed.
Thank you, Mr. Speaker. During the public hearing, there was the consensus out there with regards to, or requesting for consensus with regards to building a northern high school in the Harmon area, and it was heard by the individuals that came there to testify for and against it. Was there ever the opportunity to bring up the fact of extending the Okadu High School and their comments toward that?
Yes, thank you, Mr. Chairman, and thank you, Senator Taitui, for that question, because we did bring up the fact that we had passed legislation at wanting to try to keep the schools smaller because of research showing that if you have a smaller community, of course, the learning would be greater. However, because they know that we're having limited funds, and they were not objecting to a high school per se, Northern High School, but surely not in the site that they wanted it to, where we've identified it to be. So their request then was that if that was the case, could they take it to another property in Jigo, but that will totally defeat the purpose of trying to be able to alleviate some of the overcrowding in JFK and GW, and the closest then school to those two would have to be then in Okadu, because Okadu has more than sufficient acreage to be able to do the expansion. So I'm sorry, I don't even know if I really totally answered your question, but they felt that because these are their own children anyway, they want to try to keep them in an area then that's close to, but surely not in a congested area. And they feel that where Okadu is at, it's a little bit further away, and it's large enough, and the egress and of vehicles would not affect the immediate community because it's in a fairly open area. So I don't know, Senator, if I've answered your question completely.
Thank you, Madam Speaker. Yes, Madam Speaker, I think the whole consensus was the part about building a northern high school in a particular area, and I was wondering if the consensus came out that the request to have Okadu expanded was that of the body that was presenting this public hearing, or
Yes,
the community itself?
It was the community. When we had the meeting, we had parents, teachers, and students there. We had the Municipal Planning Council and the mayor herself. When the idea was broached that evening, immediately they had discussed it with the superintendent, and that was in the evening at the community, Senior Citizens Community Center at Dededo. When we had the meeting the following week, the same individuals all came, and they've actually then discussed it even further, and the superintendent agreed with the community, and that's why then the consensus is to have it and to expand Okadu.
Thank you, Madam Speaker.
Is that satisfactory?
Mr. Speaker, thank you so much. I mean, the reason why I was asking that is that when the public hearing was brought up, it was about a new school being built in a different area. And the opportunity for the public to comment with regards to the expansion of Okadu was one of my concerns, that it was brought forth to the community to give testimony in regards to that particular segment, and that is the expansion of Okadu and not just a new school. Hearing from the good speaker, then I guess my question was answered, but we also have to take in consideration, Mr. Speaker, that there still needs additional school in the north, regardless. Organic growth is showing that we're not up to par with the population currently, and with the military buildup, that's going to go even further. So that being said, I do support this bill and any other type of bill that may come forward to providing another high school in the northern area. Thank you, Mr. Speaker.
Thank you very much, Senator Taitui. Any other senators wish to be heard on the bill? Senator Pangilinan, you're recognized.
I have a couple questions, and I guess basically my first question is, to the author is the limitation for the Okudu expansion this $21,818,000, or is this only the authorization to utilize the qualified school bond program, and that in fact the expansion could cost $40 or $50 million? What are we authorizing herein to be allocated with regards to debt to the Ukudu expansion?
Do you yield, Madam Speaker?
Yes, thank you, Mr. Speaker and senators. That in the other bill that we had passed, the language that actually addresses and identified the funding source was in the bill that was the governor's special Bill 15S bill, which placed a cap of 6.9 for JFK and 2.9 for the northern expansion. What this bill actually, since that was passed already identifying a source, and then what this bill would do now is to authorize the government then to to allow then the contractor then to go out and issue a qualified school construction bond of $21.8 million, which means, yes, that whatever we're able to get out of $2.9 million, and I think the senator, maybe you came up with like 20-some million dollars plus the 21.8. So yes, it could realize up to $40 million for the total project.
Does that clarify your question, Senator Pangilinan?
And the payment is only for the whatever we'll be able to get from the 2.9 in terms of interest.
I think it might help everybody that's in the listening audience if it's made clear that that's 2.9 annually for the amortization, as opposed to just 2.9, because 2.9 is just 2.9.
Yeah. So that's, well then, that makes it clear. So we're allowing them to issue the entire allocation for the qualified school bond, which is 20 million, and then on top of that, another 20 million to just expand Ukudu High School, which costs only 40 million to build. I'm a little confused on that, because why would I want to, we would then have a campus at $40 million at Okudu High School that could conceivably be house 4,000 students. And do we want to do that? Do we want to put 4,000 students in a single high school? Again, so that's a question I have just from a policy perspective, because we have a law that limits the size of a high school to, I think, 1,800 students, or actually it's 1,500 or 1,200, right? 1,200, and so now do we want to double the size of Ukudu by this, as a consequence of this amendment? And so I'm not sure, I don't believe that's the intent, but that may be the effect. And so I wanted to make sure I understood that very clearly, because that is it. Because if you take a look at, and I think I'm trying to do the math right now, but $2.9 million amortized over 15 years at 8.5% is only $1.6 million or 1.7, so that additional 1.3, you basically can double the size of the expansion. And I don't know that that is, again, consistent with the policy with regards to the size of the high schools that we want. And I guess it is, because if I recall again here, we're saying that we're allowing the size of the high school capacity at Okudu not to exceed 2,200 or 2,200 students. But if we spend the entire $2.9 million, then we can have a capacity above that. And if we don't, and we're going to limit it to this 2,200 students for the size of the campus, what is that number? And I'll tell you where I'm going with this, because there is a concern because of the unknown with regards to JFK. It's still unknown what the final number at JFK is and what the final type of facility we're going to get at JFK. And until such time that we know what that number is, I'm not sure that the allocation of 6.9 million or 6.2 is enough. What happens if we go out to the financing market, we come back, and the JFK allocation is not enough, and we've already issued these bonds? Conceivably, these bonds could go first. So what happens if the allocation for JFK is not enough, and therefore we've got to do another adjustment? We've got to come back and amend this law or amend some other law that provides additional allocation there. So I'm still, the piece of the puzzle that's missing is, what is the cost of, how many more classrooms are we adding? What are we doing in terms of the facility at Okudu? And what's the estimated cost on that? I don't know what that is. We just say you have 2.9 million. Well, 2.9 million could be $40 million. And do we want to spend $40 million to expand Okudu High School? Or if we're going to spend $40 million, let's today find another site and say, let's put $40 million, because I think that's what it cost us to build Okudu, or somewhere in that range. I think it was even less than $40 million. I think it was like $27 million to build Okudu. So do we, and if we have, right now, if we're saying we have the capacity of $2.9 million under the school bond issue of issuing 21 of that plus additional 20 million, let's, find a site right now to say, let's replicate Okudu in another place and build a new high school so that we remain consistent with the maximum size of high schools that we have determined in the past as being conducive to learning for this high school. Unless we're now saying that we don't believe that limiting the size of the high school is conducive to learning, or is not as important given all of the constraints we have. And I know we all have these constraints, but I'm not against the bill. I support it, but I just want these kind of issues to be fully discussed so that we all understand where we're going and what we're doing. And I apologize, I wasn't here for the JFK discussion in which all of this may have occurred at that time, and I didn't get a chance to review the record on that. But I do commend certainly the need to proceed with finding, alleviating the overcrowding that's happening at all of the, we're saying GW is overcrowded at 22, we're saying Simon Sanchez is overcrowded at 19, and we're saying Okudu is overcrowded at 1,800 or 1,600, yet we want to increase Okudu up to 2,200. Maybe we shouldn't. Maybe we should build a new place and relieve all of the pressures on that facility, and then the other facilities as well. So again, that's really my thoughts on this. I want to reiterate, I certainly commend the good speaker and the author for continually working with all parties to try and move forward in providing the better school environment for our children and our young adults in the high school level. And it is necessary that we do this. And her determination and tenacity in moving forward and trying to find these solutions and working with all of the parties, I think is admirable and commendable, and I certainly thank her for that and leading us in addressing these issues. I certainly succumb to that and support that leadership, and will continue to work with her to try to make it happen. But again, I also think I also want these kind of issues to be fully vetted out, fully answered. And I am concerned about JFK. I am concerned of the unknown about JFK and removing the resources from there unless I'm absolutely sure that that is the number we need for the JFK project. And it could be just another month before we know what that number is. Because they have another month, another 45 days, I guess, maybe left to absolutely determine what the JFK number is going to be. And should we kind of wait? I don't want to say should we wait, but yes, should we wait? Should we wait to do that? But I guess this doesn't even matter because we've already done that. We've already decided that JFK doesn't need the full allocation because that was in the other bill that took it away. But we know that because of the requirement in that other bill that they must have a definitive number on the financing, we'll know what that is. And if they need it more, if we did this now, then we'll have to come back and amend that bill no matter what. If we don't have enough, or else we build a smaller JFK. So those are the kind of unanswered questions at this time that I am concerned about, and I'll continue to work with the speaker and trying to get that nailed down so that we can move forward on not only addressing the JFK issue, but of course addressing the overcrowding issue in the other high schools that we have, most especially up in the north. Thank you, Mr. Speaker. Sidismasi.
Please, Madam Speaker, or in light of the hour, would it be better if we just broke until tomorrow and we have, or do you want to make that?
It would be, but because the information.
Why don't you make the explanation public and then we'll discuss it
You're right,
more.
exactly. I think it's important because I don't want the public to think that somehow we did not have answers for some of the senator's question. And when we met with all the involved parties and even with GITA, DPW, the committee individuals to see really what are we looking at, and they were saying, and at $6.9 million they felt was more than sufficient because they're saying that the amount that they were looking at and considering everything that would have to be paid out was really going to be $69 million is the figure. And we did an annual interest rate of the 8.5 to see what that would yield, even if it was that high, versus even at one time at 6.75. So if let's say the interest was at 8.5, which was the max that the bill had placed a cap on the interest, that it would actually yield then $74 million. So there will be savings. And these are the figures that were given to us when we spoke with GITA. And if by chance that they're able to get a better interest rate other than 8.5, and even at 6.75, it would yield $117 million. That again would be extra savings to the government. So those are the figures that were given to me. And then to go back, because yes, like the former speaker, is that I also feel that I would like to try to keep our schools at a reasonable size, and I was really actually taken aback. I know when this recommendation came to increase the population to 2,200, and in the bill, then we actually did accommodate that on page 9. Is to exempt then this school as well to be able to increase the capacity to that level, just as we did when JFK was first being considered. That they came to the legislature and because they're building a new school, they didn't want it to be built at the capacity of what the law was saying at 1,200. They specifically asked that they wanted JFK to be at 2,200, their current population, and that was accommodated. When a piece of property was recommended by the community, the Municipal Planning Council, the only property that they were able to identify was in Jigor. They have this big wide open space going up to Wistic Road. The problem is those properties already under Chamorro Land Trust has actually been already given out, so that was not a convenient site at all to consider. I was able to get a hold of the inventory of properties for the Department of Education to try to see then where could we then actually put a property other than moving forward with the expansion of Okadu. And the only available position that is that DOE has are in Jigo, and like I mentioned was Marlboro, but that's 80 acres, and that's gone already. That's taken out of the government's hands, or will be. Then I went to Dedido, wanting to look at Dedido in the Harmon area, and all of the Dedido properties that could have been available have already been taken, and most recently with the Estumbo elementary and middle schools. So every single property under the DOE inventory has been already used by a school. So there's really none in that vicinity. So Jigo, it was just too far away to be able to alleviate some of the overcrowding at GW. So the intent was to try to stay in that vicinity to help alleviate the overcrowding. And that was the only solution then that we're able to come up with. DOE does not have that many properties where we need to build the schools. They have properties in other areas where the enrollment is really very low. But it's not to build schools in those sites. Now there is that other question that we had with the superintendent, possibly, and Chamorro Land Trust, because they're always saying is that we're depleting their inventory by taking them away and then building these schools. Could we possibly then do an exchange, of some DOE properties that you never will be able to, or it's not financially feasible to build a school in some of these areas because the population is just too small to warrant having a middle school or a high school there when we can't even fill the Southern High School. So there is that possibility to do that exchange. But with all that kind of information, it was finally decided that this was the only option that we really have, and to be able to still provide for another school there in that area. I know, and I understand exactly where the previous speaker is coming from, that we would like to try to keep the numbers down. Unfortunately, we don't have a lot of land large enough in that area to be able then to put a high school with adequate acreage up north. So I hope that would answer some of the questions. I know we are at 5 o'clock, and this might be a good time, for us to, recess and actually talk even further, and answer some of the questions that, our colleagues may have.
Thank you very much, Madam Speaker. I think I will take that as a directive to recess until 9 tomorrow morning. Let's sleep on this, and we'll be back on 413 when we resume session at 9. 9.